দিদি আসেন আজকে? দিদি আসেন আজকে? দেখুন অনেক বেশি হয়েছে। লুকিং ব্রাইটার। Yes.
Christmas spirit is there.
No,
No,
this
no.
will remain even after Christmas period.
No. I was seeking that those matters, which was appearing as item 569 to 572 yesterday. After I mentioned and brought it to their notice that I shall be mentioning, they have already taken steps to demolish the structures. These are the yesterday's photographs, 21/12/2023, 5:30 p.m. Now, I was seeking your lordship's leave, a supplementary list, if it can be published in course of the day, I shall serve notice, come back at 1:30, whatever time your lordship sees. It will not take, those matters, NHAI matters, I informed your lordship. 569 to 573, 2.
Of yesterday's list?
Yes. But those were mentioned matters, it was appearing. Unfortunately, for whatever reason, I am not blaming anyone. May I come back at 1 o'clock? My lord's officer, if it can be listed.
Can you
2 o'clock? Yes, I shall inform. Mr. Dey is appearing in one of the matters.
Mr.
Bottomwell is appearing.
He is also in a matter.
In one of the matters.
In one of the matters.
I can inform all. I can.
Circuit bench is on 27th. Can the matter wait till 27th? I can grant you.
Saturday, Sunday, they will demolish.
They will demolish the entire structure, lock, stock and barrel, everything will go. The very purpose of the writ petition is going to go.
12:30. Shantanu, supplementary list.
Great.
But please serve, otherwise I cannot take up.
100%. I am, otherwise, I shall not move.
All the respondents.
I move korbo na jodi isbi service na.
No.
All the respondents.
Yes, 100%. 100%.
12:30 rakho. Supplementary list bar kar aur give the numbers.
5 yesterday's list.
Take number gulo
572. Great.
May I permit to mention, your lordship kindly see the notice for demolition on 20, your lordship 20.
Circuit bench. Sorry, the vacation bench.
29th is date fixed,
7th is vacation bench.
Kindly give me leave, to move the vacation. Leave be granted,
Leave vacation bench move korben, leave granted. Vacation bench এর জন্য।
Please apply for the NHAI in all the matters. I am informing you. The notice is mentioned for
12:30.
now the notice being
The list item number 1.
Yes, you have the
I have the instruction, my lord. Only thing is, my lord, I need a leave, my lord, to file before the appropriate forum. My lord, this is, my lord, in challenging an order, my lord, of the the designated authority, Housing Industry Regulatory Authority, RERA. My lord, there is an appellate forum, my lord.
কোথায়? শান্তনু? এয়ারপোর্টটা কোথায়? আসছে মানে? কোথায় গেলেন? You've not affirmed it. How can you do that and complete the procedure and come back?
I shall come back at 1.
Yes, when ফিরে এলো leave to the vacation bench করে দেন. Please make it ready. এয়ারপোর্ট কোথায়? Strange. এয়ারপোর্টটা কোথায়? This also happens nowadays. Just passed over for a minute. Let them go. Yes, next matter. জয়ন্ত, মিনিমাম ডিসিপ্লিনটা মেনটেন করতে হবে কোর্টের। 10:38 ডেকে পাচ্ছি না আপনাদের কাউকে। কি The petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their grievance. Paragraph in view of the above, the writ petition being WPS such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. There shall, however, be no redress to cause.
Grateful. My lord, my instruction be kept on the record.
Oh, a written instruction submitted on behalf of the petitioner is taken on record. It seeks to withdraw it for him. Next.
Extension of interim. Item number 2.
I am for the state, my lord.
So may I file my affidavit in opposition for the response number 2?
My lord, this is ready matter, my lord.
I am also praying for a fixing a date for hearing, my lord.
Affidavit in opposition.
By the response number 2.
What about the state?
State have filed.
already-
I have
State have
already
filed
filed
a
long back.
exchange, everything is ready, my lord. My
My
lord,
lord,
earlier question-
long back.
Mr.
This is
Basu,
coming today.
Mr. Basu,
Mr. Basu mentioned the matter for fixation. Your lordship fixed it on 6th, but
No reply necessary for this.
today he served me, my lord. I will
Yes, in the meantime.
within the meantime, I will.
Affidavit in opposition submitted on behalf of the second respondent is taken on record. Paragraph, let the matter appear under the heading Group 1 hearing on 7th February 2024. Paragraph,
My lord, if it is in the month of January, my lord,
Yes,
because
all-
several matters are fixed unnecessarily. There will be a long list.
my lord,
and I cannot take
in
up.
the last week of January,
last week.
I don't think it will be possible.
my lord, the interim order is going on, my lord.
I am also praying for hearing because this interim order.
interim order will
Interim
ultimately
order
not serve
granted
his
is
purpose.
extended till 29th February 2024 or until further orders, whichever is needed.
Grateful.
No use fixing lot of hearing matters, isn't it? They have to be taken up.
Okay, February.
Next.
7th February.
7/2
It-
interim order till 29/2
Item number 3.
It our state.
Contemner my lord appear in this matter.
For the
On the PPS officer my lord I mentioned this matter.
Correction.
না না কারেকশন 2023-24টা 23 হয়ে গেছে।
Have you certified?
Oh, it will be 24 instead of 23.
Yes my lord, we are getting the, want to get the certificate.
I'll send it down today itself.
And my lord,
Nothing.
the
Aaj ke naam
certificate copy my lord today my lord. And because my lord, appeal courts did not give us liberty to file the appeal.
Without certified
Yes
copy.
my lord. Only for that is.
Inadvertent error has crept into the order passed on 6th December 2023. In the last line of the order, January 15, 2023 be read as January 15, 2024. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 6th December 2023. Shantanu, file aajke hi namiye deben. Next.
Item number 4. In this matter, I am praying for short passover on behalf of Mr. Sumitabu Chakraborty. He
Not
informed
possible.
me.
Not possible. If you want to make your submissions, you can. Or it will be adjourned. Anyone appearing? None appears for the petitioner.
This is 4 or 5?
Four.
For my letter, I am praying for passover, not to get.
Are you appearing in this matter?
Mr. Sumitabu Chakraborty is appearing. He instructed.
You are the advocate on record. Are you connected with this matter in any manner?
No, my lord.
So I cannot record anyone's name. So none appears for the petitioner. Paragraph, let the matter appear under the same heading on 25th January. Next.
Number 5.
My lord, yesterday, my lord, your lordship heard the matter. It is regarding the acquisition. My lord,
That portion of land.
yes, my lord.
Yes, the national highways was supposed to.
My lord, what my learned friend, my lord, wanted to took some instruction in this matter. So your lordship. My lord, only one thing, my lord, may I say, Yesterday, my learned friend shows your lordships
Yeah.
one notification. That is probably notification under section C1A.
No,
Uh,
till
Malad,
3D. It is
or
3D.
I don't know, Malad, it is under the 3D or not.
Till 3D it has been
Yes,
done.
ma'am.
Yes.
But in the notification, it has been stated that the land should be acquired. It was not yet vested.
That's
In
the
the
language 3D vests.
no, my lord. Your lordship kindly see the notification which my learned friend says just morning.
What does 3D say, sir?
My lord, your lordship kindly come to the 3D section 3D.
Yes.
My learned friend says the court has no power. Your lordship
Lord,
kindly
my
go through the
submissions, lordship,
proper.
maybe lordship, my senior friend, lordship, maybe mislead my submissions in a different way, my lord. My submission, once it has been declared the land has been acquired or vested, then the lordship, the court has not interfered. Several judgments, sir, lordship, I am.
No, I am not
So, lordship,
saying.
it
I
is
am
the
not saying
question,
that
lordship, this
you are
notification.
misleading the judgment.
No, my lord,
You are
because
misleading
the
the
court
I am not
cannot
saying-
interfere when it has been clear that has been vested.
My lord, your lordship kindly come to the provided part. Provided that in computing the said period of 1 year, the period of or periods during which any action or proceedings to be taken in pursuance of the notification into subsection 1 of section is stayed by an order of the court shall be executed.
There is no
So,
stay.
my lord, I am coming on. Now, your lordship kindly go through his notification first.
Have you filed the notification?
Well, I already served
My
yesterday.
lord, no notification has been served upon me yet, my lord. They said that
It
it
is
has
in
been
the,
published.
it is in the public
They
domain.
said-
It is in the public domain.
Yes, yes. And that is
একবার কি দেবে
sufficient.
তোমার
Yes.
notification?
আমি তাহলে বলতে পারবো না কিন্তু আমার কাছে
আমি
We
এক্ষুনি আমি
gave one
দিয়েছি।
notification.
আমার ট্যাপটা কোথায় ট্যাপটা দাও ট্যাপটা দাও
Your lordship kindly come to the head of the notification.
Yes.
First fifth paragraph.
Yes.
Now, therefore, upon receipt of the said report of the competent authority and its powers conferred by the subsection 1, section 3D of the said, the central government hereby declares that the land specified in the schedule mentioned below should be acquired for the aforesaid purpose.
Yes.
Next part. And further, in pursuance of subsection 2 of section 3D of the said act, the central government hereby declares that on publication of this notification in the opposite, the land specified in the schedule mentioned below shall vest after the central government. Now, your lordship kindly come to, they said 4758 government.
Where are you reading?
My lord, this serial number, lordship, that is the RS plot number 58.
47.
Yes, lordship, that is lordship in arrow. Lordship.
RS plot 58
Yes.
government.
Yes.
But how can they say that this is the government? They should, because it is a
How can
private
they
land, they should say it can be vested. That is the first one.
After vesting, whose land is
I,
it?
my lord, if they vested, if they vested the land in respect of the, they have to publish it in, my lord, it should be, my lord, given notice to the land acquisition collector. And not only so, they have said that it is a 0.3642 acres
That
of.
was where a clarification was required.
My lord, I am
Lord,
coming.
what my learned friend
The
said, lordship,
RS
challenge the validity of
plot-
this act.
RS
That
plot
means-
58. In respect of that, this is the notification which has already been, they have acquired. Thereafter, my lord, after the 3D plan has been, as per their, my lord, the highways authorities, they have been, while they are constructing the highways, they have a plan. After that, they have already, my lord, acquired the land, excluding my land. Thereafter, my lord, I have given permission as per the land acquisition collector.
You have stated this on the earlier occasion Learned
My lord,
counsel
let
wanted
my learned friend
instructions.
said that after that, after
My lord,
Learned
what,
counsel
what,
wanted to take instructions as to
Yes.
whether the entire plot has
Lord,
been
I
acquired.
am only, my lord,
Yes.
clarifying myself, my lord,
Because
that's
the document
Yes,
says
yes, my lord, yes.
0.0003642.
Yes, now, my lord,
That
my
is not the
submission
entire
is
plot.
as per this, my lord, total this 0.3505509, it is the acquired land, lordship, as per section 3D, it has been vested. No,
Plot.
no, my lord, no.
Yes.
And as per section 3D, 2, my lord, it has been vested and free from all kind of encumbrances. Lordship, now the point is whether petitioner's pillar came into the right of way of this in our acquisition or not, my lord. On the basis of the lordship, the alignment of the right of way, it has been found that the inspection has been done and marked the portion that the pillar came into the right of way of our acquisition, and that has been marked in the presence of the petitioner. That has been acquired land, my lord.
The document.
My lord, that is the question, lordship. That is the document. Very short notice. I have not been could not collect these documents in a very short notice, my lord. The only thing, lordship, my oral submissions is at the time of the inspection, after the vesting of the 3D notification, when we have made the periodical inspection, we have found that some pillar of this petitioner G+4 storied building came into the right of way of our acquisition.
That
So,
means you need some more land from the petitioner
no, my
for
lord.
the project.
Yeah,
No, my lord.
yes.
At the time of the after the acquisition, it has been came the petitioner's
No,
some
my-
portion has been came
my-
right of way.
No, my,
Beyond the acquisition, isn't it?
Some portion beyond the acquisition, lordship, within this acquisition. Petition total, my lord, the
So a
total.
demarcation is necessary. Please show me.
My
that
lord, the demarcation is necessary, my lord.
demarcation. Please do not proceed.
The my lord, my submission is, lordship, we are ready, lordship, to act in terms of the report of the demarcation, my lord. Lordship, we will take the steps lordship, after the report of the demarcation. On instructions, lordship, I am submitting,
I'll record this that no further step will be taken until demarcation is made.
my lord.
Yes.
In lordship, on the basis, in the presence of all the parties,
and
we
your
will
lordship
join
keep the
demarcation.
matter pending.
Yes, of course.
In lordship, in the presence of all the interested parties, lordship, the joint demarcation has been done within a 10 days, lordship, 7 days. We that separated the acquired portion, unacquired land, and lordship, in the meantime, we were taking any steps after the report of this demarcation.
And my lord, while they will demarcate the portion, only one thing, my lord, land acquisition collector or someone
And
of
in your presence.
my presence as well as the presence of the land, anyone, because
The
my lord,
competent
the,
authority is
what
there.
they have acquired,
will
they have
demarcate.
already acquired. After that, my lord, the land acquisition officer give me the permission. Yes, you can do. This land has
I have
not
heard
been.
the submission of learned counsel.
My lord, I bow down to your lordship.
After the acquisition, when they are approached for the road, for the
Yes,
construction
yes,
of the road, they find that one of their pillars is within your portion.
Yes.
My lord.
Yes.
It
So
is
they
their
need-
submission, but my lord, I
they need an additional portion for the road.
Lordship,
That is what I
no,
understand.
lordship, my
my
submitted total acquisition is the lordship
My lord-
of the 100, my lord. His pillar is came into our 100. After
lord,
the
my lord,
inspection, it has
what I
been
am
found.
on,
So if that is a
cannot-
full
that is in
demarcation,
dispute. That is in dispute. That's why let there be a
my
demarcation.
lordship, I am ready with this joint
my lord,
demarcation.
only
lord.
one thing, my lord, I am submitting before your lordship today, that in their original National Highways Authority, they only require 31 meter.
That is a
My lord,
different issue.
I'm
is
coming.
totally different.
What
Why has
happens?
this
What happens? Now, after constructing the highways, now they want 38 meter, which land acquisition collector said, no, you cannot. That is the problem. Now they are acquiring
Already,
the
lordship,
land.
the service road, we are already constructing the
Already service road has been
my lord, my
constructed.
submissions, lordship, if you lordship
I'll
kindly
just-
record it, it is your direction, lordship, not recorded on my submissions, lordship, for this, lordship, for my submissions.
I have to record your undertaking.
Yes,
that
my
nothing
lord,
will be
only
done.
lordship can direct, lordship, it has been better if your lordship can direct me, lordship.
No,
So,
I'll record your undertaking that you will not take further steps till the demarcation report comes. That
lordship.
cannot be that
On
is not
instructions,
okay.
my lord, on instructions.
Yes, yes, of course.
And one thing, my lord, HMC may be dropped from this case, but HMC has nothing to do in this case.
Come back, let us see if HMC
And
has
since
anything
the
to say.
sanction has been given, that's why, my lord, I'm making them cut.
The petitioner is banking upon your sanction, sir. So please do not drop out.
আমাকে বলছে fees দেবেই। কি করবো?
The notification
Fees শুধু দেয় না।
dated 15th June
এই আমাকে
2022
একটা
under section
এবার যখন
3D
বললাম,
of the
তখন হলো।
3 capital D of the
তো কি হলো তোমাকে এখন ভাঙতে বারণ করেছে?
National Highways
কি দারুণ অর্ডার পেয়ে যাচ্ছে।
Act
ভাঙতে বারণ-
আমার
1956,
যেটা তুমি চেন দিয়ে দিয়েছো, তোমাকে
submitted
জেরক্স
on
করে
behalf
প্যান্টটা
of the
সবাইকে দিও।
National Highways Authority of India.
ওটা হয়নি, ওটা
taken on
সাপ্লিমেন্টারি
record.
এফিডেভিট।
Paragraph heard learned counsels for the parties.
আমি শুনতেই পাচ্ছি না স্যার, একটু স্যার আস্তে একটু শুনতে পাচ্ছি।
If there is so much of noise, how can you hear? Heard learned counsels for the parties. Paragraph. The petitioner alleges that the petitioners submit that out of the total area of 5 quotas, 27 square feet of the plot in question, comma, 1 quota, 13 chota, 18 square feet was acquired in the year 1975 and 76. Rede LA case number 63/10 within bracket Act Roman 2. And the petitioners are in possession of the remaining area of 3 quotas, 3 chotaks, and 9 square feet. Stop. The petitioners allege that the National Highways Authority of India after having constructed a service road in their acquired portion of 1 quota, 13 chotaks, 18 square feet of land, have visited the petitioner's portion of the plot and have marked a pillar in the residential building of the petitioner. That is your case. They have marked a pillar in the residential building
G+4 storied building.
with the intent, yes, residential building, with the intention of demolishing the pillar on the ground that the said portion of the land is required by the authority for construction of road. Yes. Paragraph. Learned Counsel for the National Highways Authority of India submits, on instructions, that
My lord, on the basis of the alignment of right of way, my lord, it came to knowledge of our lordship.
that on the basis of alignment of right of way, it was discovered that the petitioner's pillar fell within the said right of way.
My
That
lord,
is your case.
my lord. And that is the acquired land, within this acquired land.
Right of this is not within the acquired land. The petitioner's pillar is away from that.
No, my lord. Within this acquired land.
No, my lord.
Yes, my lord.
I
Lord,
record her
that is not,
submission,
that
fell
1
within
kata,
the right
13
of
kata,
way,
I am denying that.
which is part and parcel of the acquired land. Paragraph. The contention of the authority is denied and disputed by the petitioners. Learned paragraph. Since it prima facie appears that a portion of the petitioner's property has been acquired by the authority and the remaining portion still lies with the petitioner, a demarcation of the acquired portion is necessary in order to identify the exact portion acquired/utilized by the authority. Paragraph. In view of the above, paragraph. In view of the above, who will do the demarcation?
My lord, the competent authority of the land acquisition, my lord.
It's not a party.
Yes, my lord. Special land acquisition officer is a party, and my lord, the land acquisition collector is a party.
It should be the collector.
It should be correct.
in view of the above, the fourth respondent is, that is, it is additional district. Fourth, yes. In view of the above, the fourth respondent is directed to demarcate the acquired portion of the plot in question. Demarcate na kore, take necessary steps korun. Is directed to take necessary steps for demarcation of the acquired portion of the plot in question in presence of all concerned, including the petitioners / their authorized representative, within 10 days?
My lord.
Within 10 days from date. Paragraph 10 days from date, and submit the demarcation report before this court on the adjourned date.
No, sir. For 10 days enough, sir. 10 days.
এর মধ্যে বড় ওরাই পারবে না।
Very well, 2 weeks.
We have to invite all.
4 days. 4 more days.
So আমাদেরও তো অফিসাররা যাবে, sir.
2 weeks. Adjourned date. Paragraph, let the matter appear under the same heading on 29th January. Paragraph, learned counsel for the NHAI undertakes, on instructions that no further step shall be taken by the authority on the in respect of the plot in question till receipt of the demarcation report.
My lord,
My lord, if that be so, my lord.
the report has been placed before your lordship. My lord, your lordship kindly, my lord, give an interim order, no coercive steps
No, my lord,
shall be
that is,
taken.
lordship, that is submission. My lord,
My lord, your lordship kindly
without
record.
undertaking, my lord, can
my lord,
your
I
lordship,
have recorded her submission.
my lord,
Now, till the adjourned date.
my lord, if that be so, my lord.
Report na kore till the adjourned date. Let us see the report, we'll proceed. It will, yes. Last day, it will be uploaded.
My lord, my submissions, my lord, only.
my lord, may I submit one thing before your lordship? Your lordship kindly give the interim order till 31st.
Not necessary.
If
This
it
will
is,
suffice.
my lord,
My lord, if lordship without the undertaking, lordship can give on instructions, lordship without the
Then I'll
undertaking.
grant an interim order.
my lord, your
I have
lordship
not
kindly.
given an interim order because of your undertaking. I've recorded on instructions.
My lord, it will appear, my lord, 29th as to be mentioned.
Or let there be an interim order till the next date, adjourn.
Yes, my lord, that would be better, my lord.
Without
My lord,
your
20,
My lord, that would be better.
Without your undertaking.
yes.
my lord, the my submissions, lordship, we will act in terms of the report of these demarcations, my lord. That is my
My lord,
submission.
then, my lord, I
If
accept.
the, my lord, what is the problem of a learned friend? I don't
Yes,
even
my
know.
lord.
If the
Yes, my lord. If your
says-
lordship will
if
pass
the
the order,
report
if your
says,
lordship
my
will
lord,
by
that there is a
application-
demarcation, then
Let there be the undertaking. Yes. Next matter.
Before your lordship calls the next matter, my lord, with folded hands, my lord, I have a request in respect of item number 4, my lord.
Item
It was passed over, my lord, and thereafter your lordship fixed it on.
Passover granted in this course,
My lord,
where everyone is
my lord,
aware
from
by now.
6:52, I couldn't come, my lord. With humble request, my lord. Kindly, my lord, I'll get hold of the opposite side. My
Please do
inter-
that. Please do that.
My lord, I'll
Immediately
come back in
back.
half an hour.
Please do that and come back. কোডটা রাখুন তো আলাদা করে কোডের ফাইলটা রাখুন আলাদা
My lord, only number 6. Only one thing, my lord, may I file one supplementary affidavit because, my lord, the permission which has been granted by the KMDA, that, my lord, plan, though, my lord, it has been written in my writ petition, that was not there, my lord.
court officer has left a file. I'll consider. Yes, item number 6.
6, Lordship, I am for the petitioner.
Yes.
Now, before going to
Sir?
the merits, Lordship, there are 7, কতগুলো private respondents? There is a number of 15 private respondents.
15.
15. Now, Lordship,
Sir?
I have served only one. Abu Taleb, all are the same address, but Lordship, this is addressee
Come back.
cannot be located. This is the
You have to serve.
return. Now, Lordship, I will serve, but in the meantime, Lordship, a notice I have received from the concerned assistant engineer Canning Highway subdivision. I'm just, as well as service, I'm praying for this report to the effect of this notice. ও আপনার এই জেরক্স আছে তো এক্সট্রা?
You have been served with a copy of this.
Yes, this copy has been served upon me. The learned advocate.
So the date and time of demarcation has not been fixed as yet.
Yes.
It's premature. You'll get your opportunity. There is no hurry.
So, Lordship,
It
on
is
the
just a
basis, even after receiving this copy of the writ petition, this notice has been issued. This notice has been issued on 5th December. So, Lordship, let there be a direction to submit the demarcation report as well as I will serve the notice.
Because there is no demarcation date, nothing. This is just an intimation to the BLLRO to hold a demarcation. That's all.
Let there be direction to submit a report at least.
Very premature, not necessary. Let it be held.
Very correct.
You can take this back. Please serve and come back. Since service upon all the private respondents is not complete.
Also, as well as hand and post, Lordship, because they are avoiding, Lordship, I've been
Serve
instructed.
by any means. Serve. 30th January.
Original nota দেয়া আছে?
Please ensure service, Mr. Mukherjee, before you come back. Yes, next.
Also, let the photocopy be kept with the record.
What file?
আচ্ছা
এটা কোথায় আগে একটা দেখি।
চলো
Next.
এই photocopy
Number 7. So I pay for the respond number 5.
I pay for the state, my lord.
Petitioner?
Petitioner? Yes.
অরুণ আছে
হ্যাঁ, কারণ
এইটা এটা কি চেয়ারম্যানকে পাঠিয়ে দেবো কনসিডারেশনে?
Yes, what is the matter about?
My lord, three-fold submission, my lord. First submission is that I applied for a long-term minor lease and it was provisionally granted. My lord, come to page first. I am coming to page 20.
Yes.
On the middle portion, that the DM has, and the order of the following application that hereby provisionally granted for the long-term mining lease is over the plot with the specified and the individual mentioned below in the terms of 2 years.
Yes.
And we are subject to the submission of the environment clearance, environment clearance of such and such on the basis of the Honorable Supreme Court's order. My lord, your lordships on the earlier occasion has already been observed that the Supreme Court has already been directed that each and every mining lease should be 5 years and environment clearance is essential. My lord, come to, my lord, I am handing over the judgment. এটা দিন তো well, this is the judgment of the Honorable Supreme Court.
Yes.
To find out that it has been clearly recommended for the 5 years. Well, now the DN has differentiated when he is taking a point that environment clearance is essential, but without the consideration that the mining lease should be 5 years. Therefore, it should be 5 years. They can't differentiate the judgment of the Supreme. Secondly, my lord, what happens, my lord? I already applied for the environment clearance certificate, but the essential parameter is vetted the map. Map should be vetted. My lord, up till now, the ADM has not been vetted the map, my lord. In the meantime, I filed a query permit application, and my humble prayer is that let my query permit application be granted and the DLRO kindly vetted the map so that environment clearance can be obtained by me. My prayer is that, my lord, come to my prayer. Read in the nature of mandamus commanding the respondent for issuing the query permit to your petitioner for week and also waiting the map for obtaining the environment. I made a representation, my lord. The representation is page 22.
Yes.
Let it be granted, my lord. Consideration the representation. Taking into consideration on the basis of it should be 5 years.
The judgment of the Honorable Court. Yes.
Lord, kindly come to the representation at page 22. The prayer is, অতএব আমি যতদিন না লং টার্ম মাইনিং লিজ গ্রান্ট অর্ডার পাই ততদিন যাতে শর্ট টার্ম মাইনিং লিজ পাই আইনত ব্যবসা করতে পারি তার বন্দোবস্ত করুন। So their prayer is short term for the time being. So we have to consider whether he is eligible for a short term lease or not. And Lord, as
Until
per the
finalization of the prayer for grant of
long-term
money.
this
Because
representation
at the when the LOI was granted at that point of time, the EC was granted to the district level. Now, as per order of the Honorable Supreme Court, now it has to be forwarded to SIA for grant of environment clearance.
Yes.
That's process is pending. In the meantime, he is paying for grant of short-term mining.
Whether that
from the
And what about the vetting of the map?
that has to be done by the ADM.
well, that representation is pending. Kindly direct the ADM to consider this representation at page
And take
22
a
within a
decision
short
within a
time and
short
take a decision regarding vetting and short term. But
Yes.
short term Lord, normally is done in exceptional
My lord,
cases.
if the map
Whether
is
they
dated,
or not,
I will get the environment clearance.
License, not a
license. It is a license.
Yes,
And the vetting. These are your two prayers at the moment.
all right.
Service, affidavit of service. It is contended on behalf of the petitioner that the petitioner was granted the petitioner applied for long-term mining lease and was granted provisional lease on 14th June 2016 for a period of 2 years, subject to obtaining environment clearance certificate in terms of the order of the Honorable Supreme Court passed in special leave petition within bracket C number 19628-19629 of 2009, as well as the order of the National Green Tribunal. Stop. Paragraph. Learned counsel for the petitioner submits that grant of environment clearance certificate is in progress, but the additional district magistrate and district land and land reforms officer, Bankura, is yet to vet the map, which is mandatory for grant of environment clearance certificate. Stop. Also, in view of the observation made by the Honorable Supreme Court in the judgment as referred to above, mining lease ought to be granted for a minimum period of 5 years. Stop. The petitioner submitted a representation before the concerned authority on 19th August 2023 seeking grant of short-term mining license till long-term mining lease is granted in his favor by the authority. Stop. The representation is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submit, counsels for the respondents submit that the fourth respondent, The fourth respondent be directed to consider the representation in accordance with law. Paragraph: in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation dated such and such within 1 month.
6 weeks.
6 weeks. Within 6 weeks from the date of communication of this order. Upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, and in the light of the observation made by the Honorable Supreme Court in the judgment passed in ওইটা দিয়ে দেবেন SLP একটু আগে যেটা দিলাম such and such এর উপরে দিয়েছি পুরোটা দিয়ে দেবেন comma in accordance with law. Paragraph: the decision taken by the authority shall be communicated to the petitioner within a week thereof. In the light of the observations made, that will cover the entire thing.
Yes, madam.
Disposed of হয়েছে
Much obliged.
হবে না ধরে করবেন কারেকশন না পাঠাবেন
6 weeks.
ঠিক আছে
vet VET হ্যাঁ vetting হয়
নামটা
yes next
জাজমেন্টটা দেবেন নামটা কি আরেকবার লিখে দেবো ডব্লিউ আমার বলছিলাম সুমিত্র ডব্লিউবিটিসিএল কে পার্টি করাতে
next matter
মানে আই এম পার্টি
Another state.
My lord, I made an application for long-term mining lease, my lord. What happens, my lord? Due to 16B, they want to reject. But when we produce the judgment, my lord, they didn't consider and kept it pending, my lord. Still it is pending, my lord. And my lord, at that time, there was no infrastructure of environment clearance. I made an application that give me the instruction. Now, my lord, I have already filed the environment clearance certificate for obtaining the environment clearance. I dated the map and everything. My lord, what happens, my lord? I have been told that it is essential for a necessary party of WBDCL. And my lord, they will consider. Now they are considering the long-term mining lease previously, pending all. Therefore, already this has been not been made party. I will make the party and my representation should be considered. This is,
you have to make them a party.
I will pay the party, I will serve a copy.
You have to serve them.
I will serve a copy then.
Then I'll consider.
I will serve a copy.
Please serve and come back.
All right, ma'am.
On prayer of the petitioners, liberty is granted to implead the WBMTDCL full form to West Bengal MTDCL. Please give the full nomenclature and address of the WBMTDCL.
Yes, madam.
পুরোটা নিয়ে নেবেন পুরোটা লিখবেন হ্যাঁ পুরোটা লিখবেন সঙ্গে সাথে দিতে হবে nomenclatureটা পুরো as respondent number 5 in the writ petition. Paragraph: the cause title of the writ petition be amended accordingly. Paragraph: the petitioners are directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on the adjourned date. এটা তো শুরুতে affidavit of service.
সুমিত তো বলেছে আমাকে
Paragraph: let the matter appear under the same heading on 24th January.
24th.
Please serve in the meantime.
On, yes, madam. I will serve.
Next.
Item number 9. No, 9. I am for the respondent number 10. But no notice has been served upon me. It has been mentioned, it will appear to be mentioned.
It is not appearing as to be mentioned. It's appearing.
No, it was mentioned, not mentioned matter, but part to in the list. But the before it is your lordship is the judge. If anybody mention matter,
Yes.
please serve notice. No notice was served upon me.
my lord, upon the government advocate, my lord, I know my
I
lord.
based on, I for the, I want
How do I know, my lord? He is not making communication. I am applying for the private respondent. It is not very, it is difficult for me to know who is applying for the private respondent.
That is served to both.
Well, I have some, my lord, the petition. Well, I do not know, my lord, who is applying for the private respondent. I have come to know from the GP office who is applying for the state. I have served.
Who is appearing for the state?
appearing for this state.
I have served.
Yes, what is the matter about? Encroachment.
Encroachment, my lord. The lordship kindly come to page 48. My lord, inquiry has already been made by the authorities, my lord, along back in the year 2015. And my lord, direction was given, my lord, to remove the construction because the construction was made not only on the state highways but encroaching my shop rooms entirely. Now, my lord, after this, my lord,
A fresh notice raised required to be. This is in 2015.
2015. Now, after that, my lord, I have initiated. I have not suppressed, my lord. I have initiated, my lord. What is the reason for delay? It was 2015. I have initiated 133 proceedings. An order was passed, my lord, for removal of nuisance. An order was passed that was set aside. This petition is pending. My lord, the statutory obligation of the statutory authority, my lord, there is no bar. Now, my lord, if requires, my lord, fresh inspection, if requires, my lord, fresh notification, my lord, let the direction be given, my lord. That will be completed.
Yes, private
But
respondent.
133 proceeding, same plea was taken, the 133 proceeding, order was passed. We challenged that order in this HON'BLE court, and that order was set aside, directed the learned executive magistrate to complete the police certainty. That proceeding is pending. Inquiry, that order was passed, my lord, for making an inquiry. What I am submitting before lordship, whether two parallel proceedings can be started, because in that proceeding, the executive magistrate was served notice upon the engineer PWD. But I'm giving the number. But this is the
language of the two provisions are different. You are aware?
Absolutely
different. But this is the order after the matter was given back to the planning agreement, 28 December 2021. What is the fate of the 133 proceeding? I am putting question to myself. Then 18th May, another notice was served.
This is 2021. After this, we are in 2023 now.
18th May.
একার নাম দিচ্ছে, দিদির নাম দেয়নি। হ্যাঁ, পৃষ্ঠা দেন।
Where is the order of this court?
That is
দিদির নাম কোথায়?
That was he is contesting, but he is the that was his parallel proceeding. He what if he responded that initiated, what is the fate of that proceeding?
দুটো দিচ্ছে।
That order of the Honorable High Court.
I want to see that order, please.
Yes, sir.
দিয়েছে।
But this is the order of the Honorable High Court.
এই তো কাকুলিদির নাম আছে।
Well, on technical ground, on the point of my lord, non-service of summon, my lord, this was my lord returned back. But my lord, statutory obligation, my lord, West Bengal Highways Act section 10 is very clear.
আপাতত কি রেসপন্ড নাই? আপাতত নাই।
10. And not in a civil showers, there is an order of the civil code also. That is also pending. That is there in the executive proceeding.
There is a rider also here. The magistrate will consider whether such passing of such order would in fact infringe domain of the civil court. So it's a conditional order.
Yeah.
So no,
Civil code, that is also valid. That order has been passed.
so no difficulty in continuing.
But
with
that
this
is
case.
initiative proceeding. What I am submitting, but in that proceeding, my lord, that IST engineer PWD is submitting the report to the sub-divisional executive magistrate.
My lord, section
Yes.
10, my lord, proceeding under section 10, my lord, that, my lord, annexer I have shown, my lord, thorough inquiry has been made. Thereafter, my lord, after inquiry, my lord, the authority has come to the conclusion, there is encroachment. Chance was given, my lord, to remove the construction. My lord, lordship is absolutely correct,
But
my lord.
facts remain,
After so many years, my lordship,
I
let a
purchased some land.
fresh inspection be made. Let a proceeding, my lord, after holding
Then, my
inspection.
lord, this is the
Difficulty in an order being passed.
then
by
what
this
I am
court.
submitting, my lord.
The
Yes.
SDO will follow this court's order.
Then may I submit one thing, my lord? by use an affidavit, short affidavit, immediate after taking
Not
that.
necessary at
Then-
all. It will be disposed of here and now.
Yes,
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 Anything
Yes,
to
yes.
add? I've heard your submission.
Then 133 proceeding, this is
Let it.
3 proceedings are there because
133 will follow this court's order.
but they are the purchaser which sold the land. They 3 suits have been filed.
That is in
Expertise
respect
degree-
of private land as far as I can gather.
Yes.
Yes.
That is not the highway.
133 proceeding man that is also the
Highway was not sold out.
That cannot be any injunction
No,
over the highway
that
property.
is a dispute. Executive man, the assistant PWD, he is submitting that. He was directed to make an inquiry to the executive magistrate.
Inquiry will reveal everything.
Set at rest, this court's order will bind everyone.
Yes, yes.
Right?
And
Then paragraph 14, you are lost paragraph 14. Paragraph 14.
Yes.
Although the proceeding was initiated they are 50 and the same was kept pending for the written test known to the authorities concerned. The petitioner had been to the office of concerned for several numbers to the proceeding. However, the petitioner made known to the proceeding under 133 was initiated against the private smart against the proceeding initiated by the state higher authorities. I got it. Then this instruction cannot be proceeded further in view of the pendency of the proceeding under 133. It is submitted that the proceeding 33, the Court of Criminal Procedure is different footing, and the proceeding under the West Bengal High Court is under different have got no nexus or connection with each other, and there is no bar. So that is their contention. What I am submitting. Suppose this applicable policy, but there is a under 10 Highways Act. Then, as a final objection, you can give your objection. If suppose if the order goes against my client, is applicable, then what I am submitting 133 petition, there is no meaning of the 133 proceeding. No meaning. Then this order of High Court.
When the High Court intervenes, there is no meaning to anything, any other proceeding.
No, High Court has
That will be
demanded.
for the SDO.
No, High Court demanded directed to complete that proceeding. High Court directed. He will proceed with the 130 proceeding. He cannot. Yes, my lord.
There is a rider to it also. The proceeding should not infringe any other act. That is also given stated by the High Court.
But may I read it, my lord? For that, my lord. একটু দিয়ে গেছে কাল রাতে ঠিক আছে
That's all your submission?
But the
I want to proceed with the order.
can give me the order. Can just yesterday.
Can you add the copy of the honorable?
Do you want to, you don't need a copy. Do you want to add anything to this?
No, my lord. The representation is pending before the executive engineer Kollani
It will be
Highway.
dealt with by the assistant.
Yes.
Where is your representation?
yes.
Page 54 and extract report.
Both parties are directed to be present before the Honorable Magistrate, Kollani. The Honorable Magistrate directed to fix scheduled date and dispose the same as early as possible. That was the direction.
CRPC proceeding
That is
cannot
the-
stand in the way of any other civil proceeding. That's settled law.
High Court direction to the 130 proceeding.
Yes. So it's a CRPC proceeding, isn't it?
The 130 proceeding.
Yes.
That is my submission before Lord.
I can understand your concern, sir. Illegal encroachment.
No, that 84, everything has been submitted to the Honorable Magistrate.
Very-
এটা জাস্টকে দিন এটা কোট করবে
Affidavit of service.
I copy.
Paragraph, heard learned counsels for the parties.
My lord, kindly
Paragraph, the petitioners claim to be the recorded owners of the plot in question and complain that the private respondent has encroached upon a portion of the state highway by raising unauthorized construction therein. The state highway adjoining their property by raising unauthorized construction therein, comma, thereby obstructing their egress and ingress. Stop. The petitioners pursuant to an application made by the petitioners before the authority earlier, comma, an inquiry was held Where is that in report?
My lord, that is at page 48. Whereas it transpires that you have made an unauthorized
And
construction.
49 our reply
An
objection.
enquiry was held by the concerned authority.
Then page
and
49. My client mane
author-
on issue of the same.
I'm dictating an
Yes.
order, sir. Please
No, I
wait.
have to.
I have already said I understand your concern, your tension, your.
No, I've not pointed. That is why I wanted to. Page 49.
কি বললাম? Comma, And upon detection of encroachment of the state highway, comma, notice under section 10 of the West Bengal Highways Act 1964 was served upon this private respondent on 2nd May 2015, directing the respondent to remove the encroachment and restore the land to its original condition within a stipulated time frame. Stop. The said notice was responded to by the private respondent on 19th May 2015, stating that he has been residing with his family in the plot in dispute without any encroachment of the highway land. Stop. No further step was taken by the authority in view of the fact that an application under section 133 of the Code of Criminal Procedure was filed against the private respondent, which is still pending. Stop. Paragraph. The petitioners submitted a further representation before the concerned authority on 30th October 2023 seeking this is a demand of justice. This is not a representation. Cannot be considered.
My lord, I
Where is
demand
your
that
representation?
my lord, I will file my lord fresh
You will
representation.
file a fresh representation. The petitioners seek to the petitioners seek to file a fresh representation before the concerned authority, ventilating their grievance, and pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the fifth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, comma, this court is inclined to hold that since no step was taken by the authority in this regard after 2015, comma, the concerned authority be directed to take fresh steps in order to ascertain the alleged encroachment and remove the same in accordance with law. Paragraph. The writ petition is accordingly disposed of with liberty to the petitioners to submit a comprehensive representation before the fifth respondent within
Within 7 days.
Within a week from date. Stop. The fifth respondent is directed to consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma, in accordance with law. Disposed of. Exactly.
My lord, one thing, my lord, lordship subject to lordship, as an abundant precaution, my lord, respondent 9, my lord, inspector in charge, my lord, may be directed, my lord, to assist, my lord, if required.
Not necessary at this stage.
My lord, this type.
At this stage, it's not necessary. You have to go till 10-4. You'll have your opportunity in 10-3 and 10-4.
Yeah, they have suit 133 proceeding, the last read.
Suit is private property. Suit is not highway.
Same land,
A suit
470.
cannot be filed with in
Yes,
respect of the highway. Next matter. Yes, are you ready? The other side. I can quote the name. You're asking for extension of interim
Yes,
order.
my lord. Can 2, my lord, your lordship may
It
take
is
up.
already fixed on 25th January, but so far as
Mention your lordship
the
that it
interim order is concerned, your lordship may deem it as problem.
Till 31st, let it be extended.
My lord, kindly sees the last order, my lord, which is at page 10 of your lordship's page.
Order একটা জয়েন্ট দিয়েছিলাম ডিকটেশন ওটা ক্যান্সেল করতে বললাম এটা হবে না হ্যাঁ ওটা যেন না করে
বলে দিলাম একবার ডাইরেক্ট বলতে পারি
Can 2 of 20.
চালু
The petitioner seeks extension of the interim order
my lord, initial order was of 3rd of August, my lord, page 9 of the brief, my lord.
granted on 3rd August 2023, which has expired on 15th December 2023. Stop. It's a hearing order. Hearing matter.
My lord, there is a direction for affidavit, my lord, but
25th January, no?
Probably, my lord.
A report in the form of affidavit or opposition.
Yes, my lord, and kindly see, my lord, we were also given liberty to give a reply.
Have you submitted your report? No.
No, lordship, till date, I have not received.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the heading motion. On 29th was the date fixed, isn't it? 25th January 2024. Paragraph, the interim order granted earlier. The WPA আর can একসাথে করো দুটো একসাথে করে দিচ্ছি The interim order granted earlier is extended till 31st January 2024 or until further orders, comma, whichever is earlier. Can 2 of 2023 is disposed of.
Lord.
Grateful, my lord. Grateful, my lord.
Lordship, I am led by Mr. Ahmed, Lordship.
Is he in court today?
Yes.
Next matter.
Petitioner.
Number 10. But I'm for the writ petition.
No, I'm for this number 5, man.
Yes.
My lord, here the petitioner's land, my lord, has been, my lord, had been acquired for in, my lord, 2002-3 for establishment of the, my lord, Sagodigi thermal power. And accordingly, my lord, page 25, my name has been featured in the LR record of right, plot number 755, area 27 decimals. This is a sole owner. My lord, thereafter, my lord, acquisition proceedings, that is page 26, APP case number 78 of 2002-3 was initiated. I am Gautam Sarkar, but they were going to, my lord, publish the award in the name of 56%. That is why I objected, and accordingly, my lord, objection, my lord, hearing was taken place twice. My lord, on 16/12/2004, nothing was done. Subsequently, I made my representation, page 27, on 23rd 4th 2010, claiming issue of land acquisition certificate. This would be land loser certificate and price of the land in favor of Gautam Sarkar, but they did not do. Subsequently, page 28, I have several representation made. Last they issued page 29 notice of hearing. Page 29 notice of hearing, whereby they have decided the hearing on 30th 8 2010, when award was passed in my favor. Malad, is the continuing process. I applied, I prayed for issuance of award, but page 30, that is their communication, last communication by the special land acquisition collector to the petitioner. This is to inform him that award amount of the land acquisition which was unclaimed. Malad, kindly consider the language unclaimed, since long period, has been deposited to the RD by Treasury Chalan number on such and such. For reimbursement of the award, the letter has been sent to the Account General, West Bengal, for refund of the same, which has deposited in the Treasury by number such and such. Until its sanction, the AG West Bengal, the said amount cannot be released. I am waiting. My prayer, two part. I cross my age limit. That is why so that my daughter or somebody else will not get any preference for land user certificate, and also awarded amount. Two prayer, specific prayer, the authority should release my award. Whether it would be released by the HO West Bengal or special land use acquisition grant, that is the business of the state authorities. Only I am praying the award should be released and land user certificate has been issued. Though I went there in several times, but nothing, no steps. My only submission, my claim and representation shows that I claim that amount. So unclaim is not true word, This is my true submission.
Where is your application claiming the amount?
Yes, first application is page 27. Issue of land acquisition certificate, it would be land loser certificate, and price of land in favor of Gautam legal.
After the notice was issued.
23rd 4.
Oh, this is, when was the?
No, it was done, deposited on, lastly on 4/10/10. Page 30, first paragraph, last line. Maybe, my lord.
After your.
Yes. My lord, maybe, but my amount cannot be, relinquished.
Yes, Mr. Don.
Award is still showing the other person's name. Awardee is the other person.
That is the objection that he raised.
Yes, but that
And where is the
hearing notice is of 2003, 2004. And we are not in a position to apprise, my lord, at this moment, what was the outcome of that hearing. He comes and says that he has a rival claim.
Page 29, the hearing date was fixed on 30th August 2010.
Yes. Thereafter,
2010, not 2004.
True, last cause of action is everything is showing 2010. So, I'll have to find it out whether
Please come back.
Award was rectified. Kindly, hear me. Whether award is rectified, and for that rectification, his name should appear in the record of rights. His name is still not showing.
A hearing was called. What happened? What was the effect of that? What? Yes, that.
I'll have to.
Now, I am appealing for the office of the Principal Accountant General.
Yes.
This is the list which has been forwarded to our office by the end of the district judge. There is a lapse deposit statement in which, in respect of APP case number 78, some other 267 and 268, I believe, some other person's name are there.
Unless the objection.
Yes, but unless this record is corrected by special land acquisition officer, we cannot issue authority.
Yes, you cannot. The state has to take steps.
Yes, I'm good.
At a report file,
নামটা দিয়ে দিন ঠিক আছে
my lord
affidavit of service. It is submitted on behalf of the petitioner that the land of the petitioner was acquired by the state respondents and award declared the names of persons having no connection whatsoever with the land. Stop. The petitioner filed an objection to the said recording and requested the authority to pay compensation in his favor and issue land loser pay compensation and issue land loser certificate in his favor. Stop. A hearing was called by the authority on 30th August 2010.
30th August.
30th,
That is
and you attended?
I attended on that day. I have stated in paragraph number 8 and 12. On that date, award was published in my presence. Award was published.
In whose name?
Malad, in my favor.
It was changed. The name was changed.
Yes. They have stated. Though our copy of award has not been supplied.
Stop. On the said date, the petitioner appeared before the authority and his name was recorded as awardee in respect of this is his submission. I'm recording.
Kindly direct him to make private respondents a party to these proceedings. Otherwise, if state wants to give it to in favor of him,
these two persons,
they are not made party in this writ petition.
And they will be affected by the result of the writ petition. Please add them as parties. Ki bola? And was present. Awardee by the authority in his presence. No compensation has been paid to the petitioner till date, nor has land loser's certificate been issued in his favor. Stop. Paragraph. Learned Counsel for the state respondents seeks to take instructions in this matter since the hearing was held sometime in 2010 and no other subsequent document has been appended to the writ petition by the petitioner. Paragraph, let the matter appear under the same heading on 30th January 30.
2010's document, my lord, I'll have to find out.
You need 1 year? More than 1 year.
Give me some listeners. 2010, we are in 2023. Record keeping is pathetic.
Very well, 15th February. Sufficient.
15th
February.
No.
February.
Well, between February, perhaps is a holiday.
Second day of
second day of Saraswati Puja. Dekho na.
Oh, that is 15th.
Yes.
So, well, 16th. 16th in that case?
16th.
Yes, in all probability, yes. So, 16th.
16th. Well,
19th.
I out of station during that. Any day, or prior to that week or
7th.
7th.
7th February ko. Ekdam shurute on prayer of the petitioner, liberty is granted to implead. These are the names. Parmuj
and
Kuddus. Well, I have given the record, man.
Karmuj.
Faruz, F.
Farmuj Sheikh. Please give the names to my officer.
I'm giving Farmuj.
Yes.
FAR.
The name and the addresses. Yes.
Yes, madam.
Farmuj Sheikh, address deven tapor, and Kuddus Sheikh as respondent number 6 and 7 in the writ petition. এটা একদম প্রথম ওই নাম দুটো উনি দিয়ে দিচ্ছেন না ডিটেল নাম আর অ্যাড্রেস
Get fillers.
নেক্সট
এখন এসছে কেন এটা তো এখন এসছে কেন
Advocate on record.
কারেকশন Yes.
Item number 11. Urgency supplementary.
You are in court today?
Problem they have solved. But I have admitted that this. I am a lessee of a sand block. I am a lessee of a sand block. I deposited the royalty, extract the sand, but I kept there. I could not sell it. So I become my property. I am the owner. But they are not issuing challan to now to carry.
Transport, yes.
Transport portal is not been open, so I cannot apply for the challan. I cannot do this. This is the subject of the matter. I prayed for my lord for direction to allow me to withdraw those. Now my landlord has a talk with him. Probably his client is agreeable now.
No, so not my client. There's a meeting of the ADM of all the districts that they have disclosed in their supplementary affidavit that in those cases where the lease has been expired and the advance royalty has been paid, in those cases, time has been granted till 31st of December for disposal of the sand in which advance royalty has been paid. So in terms of that order, they have disclosed in the supplementary affidavit, the minutes of 19th December, direction is there. Dispose of sand within 31st, advance royalty payment.
Where is the decision?
So it was communicated in terms of, if you also kindly consider page 12. Yes. In pursuance of the decision of the meeting of the district level sand committee and district committee for competitive bidding, so and so, it is hereby ordered that all sand blocks, monsoon stock, auction stock, and desilting of the district will be disposed of within 31st December, except the expired leases of stock. In case of the petitioner, his lease has been expired. No extension of time is thereby allowed.
Except for expired leases.
Yes, no, there is the undisposed stock will be seized and disposed of as per provision of law by the competent authority. So here the case of the petitioner, they have paid advance royalty.
Where is that recorded? It says that this doesn't cover.
Unless I pay royalty, I cannot extract.
No, this doesn't cover the expired leases.
No, my expired though, I filed a writ petition due to COVID, I could not extract, so kindly extend it. That is also pending. I'm not on that now.
Yes, but this doesn't apply to
Yes,
expired
I am
leases.
told by over telephone, but the order shows something else.
Yes. How this doesn't help the petition?
Yes.
The decision is there. Kindly come to page 87.
Until your lease is extended, it is held to be expired lease.
Even if my lord is expired, already I paid, I became the owner of the sand. So there is no bar in allow me to extract.
I'm saying that this will not
This
help
may
you.
not apply, but your lordships can direct. Because admittedly, I have paid. Page 84, kindly come, 84.
I find there is a representation.
Yes, in the event the royalty has been paid.
Kindly come to 84.
Yes.
84, with reference to the above, this is to bring your kind notice that the following lessee have applied for issuing challan against unsold sand which was stocked before the date of expiry. As the lessee were expired, they could not open the portal for issuing challan.
Yes.
Then, my lord, a decision was taken at the meeting of such and such. The portal may be unlocked from the end of the day for a single time opportunity to dispose of the unsold stock by the lessee. So this opportunity I am trying to get.
That is over.
They have not opened it.
This is in July 2023.
Right, but up till now they have not opened it. I am going on writing. It is open one time. Let me clear the unsold stock. And my lord, 11 lakhs 98 cubic. So it cannot be by one day. Cannot be cleared. Humanly not possible. This part is admitted that I have paid and stacked.
Please see the last line.
Yes.
You are
requested to
requested to
kindly take necessary steps for unlocking the portal for selling out the stock till
30th September
So
2023.
that is the internal communication. I say I am squarely covered by this, but you open it. Allow me to withdraw.
Yes, so I think you need to take instructions on this, whether it was opened at all, because learned counsel says it was not.
Never opened. Otherwise, could have
Lordship,
taken it up.
kindly keep this matter immediately after reopening.
It was opened by 30th September.
My lord, if your lordship will come, supplementary list is 3
Supplementary list.
Supplementary.
Supplementary.
Yeah, my lord, now they are threatening me to seize. That's why the urgency cropped.
Page 3.
Yes, ma'am.
Yes.
First paragraph, last 3 lines. My lord, he was directed to file appeal, and that appeal was.
That is separate thing. That is extension.
That is a separate issue.
That is the extension of that, ma'am.
Yes.
Extension of that.
That's what I said. That now it is expired lease until it is extended. But this is a separate issue altogether. The stacked minute. Yes, that
Purchase
has,
material. I should say purchase materials.
that
Stacked.
has to be transported. That's a different issue.
My lord, if the extension is there, my lord.
Extension is not there as yet.
Irrespective of extension, I can solely.
Extension is pending.
Extension is pending before the appeal authority.
Yes.
Yes, but this is already mined.
That, my lord, whether.
Huh?
That.
That's why I asked
Sure.
Mr. Shah if you can please take instructions on this.
Lordship,
Or then, my lord, stay, my lord, paragraph 12, page 12 of the.
because in that it's
That has
says
no
that
connection with you.
Yes, yes, yes. Kindly seize. It will be seized. My materials will be seized. My purchase material.
no,
Where
that
is
is
that
in
stated?
respect of
Paragraph.
where the uses are
Page
pending.
12.
Expired.
Yes, in expired. Lordship,
Expired.
Mine is also expired. I'm সব জায়গাতেই আছি। The unsold stock will be seized and disposed of as per provision of law. Kindly, so far I am concerned, let it be stayed.
Yes.
in this case, Lordship, since his lease has already been expired, so that should not be seized. If your Lordship kindly peruse the language.
Kindly make it clear, it
dispose
will
of
not be
within-
seized.
Yes. 31st December, except the expired leases. Stop.
It covers expired lease also insofar as the seizure and disposal is
Disposal is
concerned.
concerned. In both cases.
Because no opportunity is, no relaxation is
Lordship,
given to
kindly,
the.
kindly.
So insofar as the petitioner is concerned, let this be stayed.
Lordship, so far as this.
Yes, yes, only that part.
And it can be disposed of if the instruction is there, as my left hand has said. That my property, let me take it out. That's all.
Please come back with instructions. It's a very short matter, can be disposed of.
That is 31st December after you. My lord, he can find an application before the authority. Authority will consider that.
এই এক
And
consider
I-
শিখে
I-
রেখেছে।
I-
Consider,
I-
consider, consider.
31st December তো হয়ে যাচ্ছে।
Authority has already said that they have seized it. What consideration? My lord is here, season of the matter.
Instruction of chaos will be
You can do one thing, Mr. Basu. You can actually file a representation and I can direct consideration in terms of page 84.
If my lord says I bow down, but so many representation, no action. That's why I am before my lord.
It's a disposal, my lord, no action. That is
উত্তেজিত হওয়ার কিছু নেই।
then you will get the opportunity, my lord. Otherwise, 31st December.
They will come back. Then in that case, come back.
I think this is a simple thing. I am the owner. Let me take it away. Nothing else.
No, no, it is as simple as that, but then let Mr. Sharma come back.
Kindly
Yes.
keep this matter immediately after
He
reopening.
told me.
Yes, yes.
Yes, but
Till the adjourned date, let it be.
Lordship,
I can
stayed.
stay that part.
Yes. The petitioner. It is submitted on behalf of the petitioner that having been granted long-term mining lease and upon payment of royalty and other ancillary revenue, the petitioner extracted sand from the leasehold
কি আর ছিল পাখি নাম
Plot.
হ্যাঁ আর ছিল কি মহিলা না পাখি
একদিন দিনের মিত্রি ঘরে একটা হিয়ারিং চলছে সকাল থেকে চলছে হচ্ছে
You could not transport due to COVID.
COVID and other market. In fact, my lord, market is not there.
The petitioner was unable to transport the stock from the leasehold area due to several reasons. You have applied before the authority for opening the portal.
No, it's
Yes, yes, yes.
ATM recommended
Yes.
it for opening the portal for a particular period
We
in
also
respect
prayed
of
for it.
petitioner and two other that period has expired.
Would also prayed for it, but not granted.
কি বললাম?
কি বলছি আমরা শুনছি না দেখ
For which he seeks a direction upon the authority to open the portal for issuance of challan in his favor so as to enable him to transport the mineable reserve already extracted by him during the lease period. Stop. Paragraph. It appears that the additional district magistrate and district land and land reforms officer, Purbo Bardhaman, by a letter issued on 19th July 2023 to the chairman and managing director, WBMDTCL, requested the latter, LATTER, to take necessary steps for unlocking the portal for selling out the stock till 30th September 2023. Stop. The letter refers to the petitioner's lease besides two other leaseholders, two other lessees, besides two other lessees. Stop. Paragraph. Learned counsel for the petitioner submits that no step has been taken by the authority pursuant to this letter. Stop. In the meantime, the additional district magistrate has passed an order on 19th December 2023 directing that all sand stocks of the district would be disposed of within 31st December 2023 except the expired leases stock, except the expired lessees stock. No extension of time was granted for the expired leases. Stop. The order further records that undisposed stock will be seized and disposed of as per provision of law by the competent authority. Stop. The petitioner apprehends that his stock may be seized and disposed of by the authority in terms of this order. Paragraph. Learned counsel for your respondent number?
I am respondent number 2.
For the second respondent seeks to take instructions in this regard. Paragraph. Let the matter appear under the same heading on 30th January.
Let's keep this matter earlier also.
Earlier?
Any day.
Yes.
Very well. 11 January. 11 January.
11 January.
Paragraph. The order passed by the additional district magistrate and district land and land reforms officer, Purbo Bardhaman, on 19th December 2023, insofar as the leasehold plot of the petitioner is concerned, be stayed till the adjourned date.
That's right.
Make it 1 week after the adjournment. if some other is not, cannot take up the matter.
Very well. 31st January or until further orders?
That will
Be stayed till 31st January. The agenda কেটে দিন 31st January or until further orders, comma, whichever is earlier. Urgent certified website copy. Stay out of class. Next.
Number 12.
This is also the same query. When a petitioner was applied for the same query for grant of lease. DM has given lease for 9 acres something.
Yes.
But when I operation of this area, I have deposited 3,42,000 as a royalty. I went to work that plot, but I have seen the 6-acre plot which has not been due for query. This is within the 200 meter of the river bank. But I work only 3 acres of land. And thereafter, I applied for extension. That I could not, paragraph 8, I could not run the total plot which you have given to me. You should have known that this will not be done. But that extension has not been given till date, I am hunting. And also they have not been returned the money, royalty. They have given royalty for 9 acres, but I do only work on 3 acres. But I have applied for before the DM district magistrate from 2016, that is time to time I have applied, they did not take any steps till date. Either return my money or to give lease. That is pending ever.
That will be considered by the authority.
Consider করবে না।
তোকে কি ম্যান্ডেটরি অর্ডার দেবে কিন্তু
তো তুমি যতগুলো তুমি জেনে শুনে আমাকে এইসব করেছো, বেশ করেছো। হ্যাঁ, তোমার হাতে পাওয়ার আছে বলে বেশ করেছো।
already filed an application, my lord, that will be considered by the ADM, not by the DM. That is the ADM is the authority.
Paragraph 8, I have specifically stated that out of 9 acres 17 decibel, I got only 3. আমি এতদিন বাদে আছি না, আমি দিয়েছি সঙ্গে সঙ্গে। আমি দিয়েছি।
Let this be considered by the authority within 1 month.
Well, a specific direction has to be, I have taken a specific point that for that reason, I am suffer. They have taken royalty for 9 acres, but I do work only 3 acres. They know very well that within the 200 meter of the river bank, I could not do the work there. They have taken money from me.
Did you inform this to the authority during pendency of the lease?
Yes, Lord. Earlier also I have given. I have said so. Let them extend the time, Lord. Otherwise, Lord, I am a huge loss.
Yes, the authority has to consider, the court cannot impose upon the authority, isn't it? The writ court cannot impose.
Let him.
Because I do not find any letter during pendency of your lease to the authority.
That I have given, Lord.
This is only after expiry of the lease, and that
For extension.
Did you immediately inform the authority that 200?
That was done, Lord.
According to provision, my lord, before taking.
He has to take inspection, but that is not done yet.
Demarcated, my lord.
That is generally not done.
Application 2016. Now he has come, my lord, 2000.
This was.
It's the responsibility of both the lessor and the lessee to hold an inspection and see the viability.
Totally, my lord, the petitioner. The petitioner will see first. That is whether the total area is there or not.
All blame upon us.
That is the problem.
Full responsibility of the lessor.
But I have already told them.
And I do not find any document that you inform the lessor.
That is true. That is true, Lord. That is not with me for that reason. But let them to consider directly.
Within 1 month.
By the ATM month.
Affidavit of service. A learned counsel for the petitioner submits that the petitioner was granted long-term mining lease in respect of the plot in question. Vide 2011 it was granted. 2011.
Yes, sir.
Yes, sir.
Up to 16 months.
Yes, yes, yes.
Vide deed of lease executed on August 10, 2011.
August 10, 2011.
For a period of 5 years.
Yes, sir.
Stop. Though the lease was in respect of 9.17 acres of land. Though
Paragraph
the
8.
leasehold property, though the leasehold property comprised 9.17 of 1.97 acres of land, comma, the petitioner was able to excavate only 3.00 acres, since the remaining 6.17 acres of land was within 200 meters of the river embankment and therefore could not be utilized. Stop. The petitioner.
That is
his submission, yes.
submission. Right?
No, I deny.
The petitioner submitted a representation before the concerned authority on 2nd August 2016 requesting extension of the lease for a period of 24 months, comma, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph in denying and disputing, paragraph in denying and disputing the contention of the petitioner, comma, learned counsel for the respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Next.
Item 13. No, I am for the petition.
Supplementary recommendation.
This is my affidavit of service.
Yes.
This is relating to, my lord, filling up of the water body that is non-Julie, and my lord, construction by the state authorities as office call. My respectful submission is concerned is this, my lord, in 2016 this issue was raised. I made the objection, and my lord, subsequently another issue also pending between the authorities and myself, my lord, that I have a plot of land, my lord, for access that land. I prayed for construction of a culvert so that I can get the access to that. My lord, that was recommended by the authorities after 2016, in 2018. But subsequently, recently, my lord, they are making construction of the office ghar of block plan land homes officer that
ওটা বলে দিন যে ইনজাংশনটা পাননি
my lord, I have also prepared, I have already
Where are they raising the construction?
my lord, the state authority
Where are they raising the
on the non-June, on the plot, particular plot
on
number is,
on
my
a
lord,
state land.
it is non-Julie, after all, it is a water.
How are you concerned?
My lord, filling up of water body is not permissible on the Fisheries Act 17A 1.
So it is a public interest litigation.
My lord,
You are moving on behalf of the public
yes,
at
yes.
large.
No, not on behalf of the public, my lord, I have personally moved this application. It is not
But
that,
what is your personal interest in the matter?
my lord, I shall be affected because
will
my
you
lord, filling up of water body, anyone can raise the objection. It is not that the-
Anyone can raise the objection.
unless a
True.
group of people comes before the court, my lord, it cannot be
Public
entertained.
interest litigation not necessarily by a group of people. It can be done by one person also on behalf of several groups.
But even if, my lord, even
If
if,
your personal interest is not affected, this is a public interest litigation. You are against filling up of pond.
yes,
That is absolutely correct. But this is not the forum. This
No,
court
my
is not the forum.
my lord is saying that I am to file public decision before the division bench. But the difficulty, in that sense, I have nothing.
Because it's a general litigation, isn't it?
Yes, it is. But the issue is that they are filling the nine.
Being unsuccessful before the civil court, he wanted to have an access
this,
through the state's land, though he has an alternative land access, ingress and egress from his land.
That is a different.
Yes,
That is immaterial.
there,
It's not
there
the state's
he
prerogative.
was unsuccessful, then preferred an appeal, misappeal, then his prayer was rejected.
that is a
Thereafter,
different
this
issue.
writ petition
That relates
by
to
filing.
access to my land. That is a different issue. And here, my lord,
This
it
is
is a different
purely
issue.
for filling up of water body.
Noyanjuli was no more there. Noyanjuli
My lord, I have
had
annexed the document.
converted long back. The
I
recording
can
which,
request learned counsel to come back with a report, but that will that help?
well, my lord, I'll take the point of
They are making-
maintainability.
Yes.
I'll take the point of
They are
maintainability.
carrying with the construction hurriedly, my lord, I have annexed the photographs.
তাতে কি হলো?
No. My only question is how is your personal interest affected? If it is not, you have to go for a public interest litigation.
My lord has observed
Noyanjali
that
doesn't belong to
person
you.
can also file the public interest litigation.
Anyone can file.
Everyone can file.
Yes.
But if that be so, my
And
lord,
this is for the welfare of the public. Your submission is for the public at large.
and my lord, section 17A,
That's clear.
that's clear
Cannot
for
be-
my.
Yes.
Therefore, it is not that the public interest.
And
litigation is
so far
got
as I can recall, the Honorable Chief Justice has been taking up these issues. A bunch of matters were pending before the Honorable Chief Justice, so far as I know. So I'll release the matter for
But
filing
in
it
the
before the
meantime, I
appropriate
shall be,
forum.
they will complete the construction.
File it immediately. I'll release it and send it back here today itself.
But specific provision is there, my lord, war. But section 17.
I understand. That is no dispute. I understand your point. But how can this court deal with it?
26 can be entertained. It may be, my lord, before the
26 is not
division bench.
everything under the sun. Different courts are there.
But
different
I'm
courts
not
are
making
necessary.
any submission on merit at this moment. Let him, my lord,
Let me release, please approach the
Yes.
appropriate forum.
But in the meantime, the vacation is there and my lord, they are making construction. But kindly,
The vacation bench is there.
when there is specific bar in the section, my lord,
No disputes.
that
sir. I
bar
repeat.
does not
and my lord,
relate to government.
Mr. Dhar,
and it is not that, my lord, the section article 226 cannot be invoked.
can be invoked. Public interest litigation is also Article 226.
Therefore, I am submitting for lordship. If the public
Otherwise, there wouldn't have been any separate forum for a public interest litigation. It could have been done everywhere.
my lord,
All courts, all benches could deal with it.
my lord, kindly consider regarding the unauthorized
Please
construction.
just tell me one simple thing. How is your personal interest affected?
My lord, I am there, my land is there. Therefore, if the water body is filled up, my personal interest will be affected.
How? It is not your water body. It's not owned by you.
My water body, if it is.
So you are well aware of what is
Nobody
coming
is
from.
entitled to fill up the water body. This is the law of the land.
We are
Kindly visualize. Well,
repeating these conversations will not really help. Let me release it, please.
I am giving one example, my lord. Therefore, if there is any unauthorized construction by any third party, a third party can raise objection not a private, public interest by your individual. My lord, that is entirely.
When the personal interest of that person is affected,
No,
his
no
egress
locus is
ingress
required to be
being
looked
blocked.
into. No locus is required to be looked into, even if as soon as it is found that the construction is illegal, that is required to be stopped and that is required to be demolished. Every day, my lord, we are moving the writ petitions, not the public interest citizen.
One small line is added there, sir. Please remember. Obstructing my egress and ingress.
No,
If
no,
that is not there, it
I am
becomes
not
a
at all,
public interest
I am
litigation.
not even a heavy, I am not a resident of that plot. I am not subsequent, side
It is
by
an
plot.
adjoining plot. Whenever these orders are passed, it is
No,
always an adjoining plot.
Question is whether any illegality is going on or not.
Show me one example, sir. I would like to learn.
The unauthorized construction, demolition of
I
unauthorized
have been
construction.
dealing with lots of cases every day, and in every case, it is seen that the egress and ingress of the private person is encroached upon, is obstructed. Only then it becomes, it is under before this court.
Well, so far unauthorized construction.
I think we are only spending time unnecessarily, Mr. Mohan. It appears that the subject matter of the writ petition is in the nature of a public interest litigation. Paragraph, the petitioner, liberty is granted. Liberty is granted to the petitioner to withdraw the writ petition and approach the appropriate bench for redressal of his grievance. Paragraph, affidavit of service filed by the petitioner and report submitted. This is your report. Report submitted on behalf of the state respondents are taken on record. I'm sorry, Mr. Mohan, can't help. Next. That urgent certificate was checked for.
I petition. Sorry.
না আমি তো লিবার্টি দিলাম তাহলে আর দরকার নেই আর না তো এটা করুন না এই পিটিশনের লিবার্টিটা কেটে দিন ওটা দিয়ে ওই পাবলিক ইন্টারেস্ট লিটিগেশন ওখানে একটা লাইন খান করো দ্য ম্যাটার ইজ রিলিজড ডিউ টু ল্যাক অফ ডিটারমিনেশন হ্যাঁ ওই লিবার্টিটা কেটে দিন Yes, next one.
But I appear on behalf of the petitioner.
Yes.
Now, Miller, this is a matter where, Miller, my clients are the owners of some lands. Now, Miller, there is obstruction in the egress and ingress of the petitioner in the land. Now, the grievance is that without initiating a proceeding for initiation or for acquiring land, now, Miller, steps have been taken to construct a wall in respect of some lands of the petitioner. Now, I find, Milord, that under the New Town Kolkata Development Authority Act, under Section 37, Milord, I'm just handing over to my lords for my lord's kind convenience. Section 37, Milord, gives an unequivocal power to acquire a land, but that has to be done under the recourse to law. It is well axiomatic, Milord, that any proceeding has to be initiated upon giving an opportunity of hearing and thereafter steps be taken.
Yes.
Now, I further made a grievance in the present writ petition is concerned that, Milord, there is no sanction of plan, no statutory vacant space had been left. And further, Milord, I had also, Milord, made a allegation that we are in possession of the lands, but without taking the recourse to law, they are proceeding. Therefore, my lord, your lordship, and what we did, my lord, because we had filed my lord complaints before the authorities. That, my lord, I have annexed. It starts from, my lord, possibly, my lord, from page 71. All the authorities, my lord, with all the endorsements I have. Now, my lord, at least, my lord, the Kolkata, the Newtown Kolkata Development Authority, my lord, they should take a decision and they should communicate me. It is unheard of, my lord, that if you want.
Construction is over, complete.
No, it's going on. Some made, some, my lord, remaining, and we have also, my lord, taken some photographs. Huh? Yes. My lord, just this is one photograph, but I cannot make a submission on the photograph because this is not part of an annexure. However, my lord, I leave it to the kind consideration of the court.
I am not the answering respondent. I appear for WB HIDCO. The entire allegations is against Newtown Kolkata Development Authority.
Who is appearing for?
But I do not know, my lord. I am appearing for WB HIDCO. I have been made a party, and a complaint was also given to me, but I have nothing to do with the land.
The party?
But HIDCO has been made a party. Your lordship will kindly have a look at the cause title. My lord, respondent number 2 is HIDCO. But really, my lord, the answering respondents.
Collector Parashar, North Tirupur Parganas. I do not find HIDCO.
The answering respondent will be 4, 3 and 4. I'll get 4. Miller,
HIDCO included?
I think, Millard, I must not make any comment because which I do
There
not.
is a service on NKD.
Affidavit of service on it.
Who appears usually for NKD? Are you aware? No.
We appear for that.
দাঁড়ায় জানবেন
নতুন মামলা নিয়ে এসছো
না না
NKD এর হয়ে কেউ কোনোদিন এখানে মামলা হয়
My lord, what I can say is in some puja matters, my lord, we have been engaged for NKD. That's the only thing. In Durga Puja matters. Once we were
It has
engaged,
been
but
served.
now, my lord,
Will you please take instructions?
but we have not got any instruction like that.
My lord, consider the application by the NKDA. Whatever, what is the harm of the? There is
that can the objection which has been made, Millard.
Consider that.
That suffices, that can be done, but nothing on merits because they are not there.
Yes, my lord. That will be considered by that authority without any affidavit of service specification.
Shall I give them direction? Let this be considered.
Yes, your lordship may be giving me some. I appeal to my lords. I have nothing more to
That's
say.
the difficulty in their absence. I cannot pass a restraining
But
order.
Millard, it seems, Millard, page 15 of the affidavit of service.
Yes, it's served.
Yes, it has been served. Now, Millard, I leave it to my lords kind consideration.
Shall I request you to serve a further notice to them and come back?
That may be done.
If you
Can be kept on the reopening, my lord, the first day on reopening.
Reopening এ কি হবে কেউ জানে না।
Third, on the third. On the 3rd of January, my lord.
I cannot pass a stay order.
No stay order is there, my lord.
But there are other respondents also who are not also appearing. There are several other respondents. Your lordship will kindly.
State.
State
They are state respondents.
State আমি আছি।
এই সবগুলো গ্রাম পঞ্চায়েত
No, not
BLR
গ্রাম পঞ্চায়েত
BLR state.
BLR তো আমার।
Officer in charge Rajanat Police Station state.
That is state. Panchayat has been served. 132.
All served.
Yes, all appear to have been served.
All served, my lord.
আমারও নেই
All are served.
আমি বলবো objection
Yes, shall I pass such an order? So let it be within 1 month.
Within 1 month, my lord, that will be.
At least my land, the egress and ingress of my land That should be, my lord, preserved.
Cannot pass a restraining order without
I
hearing.
understand, but
That's the difficulty. I can only with, since
but
they are
my
not
lord, if
appearing.
my lord, if they my lord proceed to
So why
make
don't you
further.
serve a notice and come back? I can
that-
grant you
that-
leave to appear before the vacation bench in that case.
No, my lord, kindly do not, my lord, I appeal to my lords. I personally, my lord.
Then let them dispose of. Well, no further encroachment till
Consider
disposal of
করে
the
দিয়ে দে,
litigation.
কাকে let them.
That
My
is
lord, I say, my lord, what I, after reading the brief, what it came to my mind, that either they have to file a report or, my lord, the authorities have to be directed to take a decision. Whatever the decision is forthcoming, then if I am aggrieved and if there is any clinching evidence to that effect, then I can, my lord, certainly assail the particular order.
Then we will pass an order directing them to file a report then.
So let them
File a
whom
report.
to file a report.
On NKD. NKD has been served. They will communicate once again the order to the NKD.
Representation will dispose of within a month in that case.
I cannot say further in this matter.
Yes. Affidavit of service. None
আমাদের
appears for the
problem হচ্ছে
New Town Kolkata Development Authority and Chandpur Gram Panchayat, CHAND, Chandpur Gram Panchayat, despite service. The petitioner claims to be the owner of the plot in question.
কিন্তু তোকে বললে পরে তো তুই পারবি না, বলিস না এটা কি দরকার ভাই।
New Town Kolkata Development Authority has been constructing a wall,
Yes.
by encroaching upon,
My junior is.
by encroaching upon a portion of the petitioner's land without due process of law. The said construction therefore being illegal and unauthorized. Stop. The petitioner submitted a representation in this regard before the concerned authority on 4th December 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph upon consideration of the submission made on behalf of the parties represented, comma. This court is inclined to hold that since a comprehensive representation submitted by the petitioner before the authority is pending, comma, the concerned authority, comma, being the executive officer.
Miller, this is the chief executive officer, Newtown Kolkata Development Authority.
Respondent number?
Three.
Be the fourth respondent.
Miller, he is respondent number 4.
Fourth respondent.
No, 4 no, 5.
The executive engineer.
Numbering bhul acha.
Pending.
Actually, Miller, there is a mistake. The second, then Miller, 2 are identical, Miller, of the numbering. Kindly indicate that the executive officer of the New Kolkata, Newtown Kolkata.
Score here. No difficulty.
Yes.
কি বললাম?
It had actually serially 4 আসছে।
Comma, the fourth respondent, the executive officer, comma, NKDA and ex officio special secretary to the government of West Bengal, comma, being the fourth respondent herein, comma, be directed to consider and dispose of the representation submitted by the petitioner within 1 month from the date of communication of this order upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, comma, the authority being the fourth respondent is restrained from encroaching upon any portion of the petitioner's property. Pending disposal
I'm good.
of the representation. Petitioner's property without taking recourse to law.
I'm grateful to
Without taking recourse to law. Paragraph, since the fourth respondent is not represented, comma, the petitioner is directed to serve copy of this order along with a copy of the representation to the fourth respondent at the earliest.
May I say an unusual prayer? If it can be made a server, though this is the last day.
Yes, it will be done. All the orders will be
No, my lord, I am troubling my lord.
uploaded. No, not at all. It's my duty. All
No,
the
no,
orders
no,
will be
no.
uploaded.
After all, my lord, on the last day of the vacation, my lord, most of the lawyers, my lord, they are reluctant to work.
No, but for us, I ensure all the orders
No,
be
no, no.
uploaded before I leave court.
I'm grateful. I say, my lord, no.
All the orders will be uploaded.
I'm grateful.
সব order upload হবে আজকে, হ্যাঁ?
Last minute again.
সব upload করে বাড়ি যাবো। Yes. That 12:30 matter. Let it be.
Item number 15, your lordship, upgraded my matter yesterday.
It will be taken up. It will be taken up. Don't worry. There is a 12:30 specially fixed matter. So let me take. Are both the parties ready?
Yes.
The 12:30 matter.
কোনটা ওই চারটে একটাই
Yes.
I'm for the Union of India, my lord.
Your phone?
My lord, Union of India. National Highway.
Now kindly takes up Bashanti Bomix 28021 টা দিতে হচ্ছে।
Says 28019.
Kindly takes up 21, both all are same. And actually, Mr. Chakraborty, my lord, in order to ease my burden, has given me 28021.
That's the second matter. Yes.
Just 2 minutes time I shall take, my lord.
State who is appearing?
NHAI is appearing, my lord. Union of India is appearing. My lord, a compensation has been determined. I have received the compensation in my bank account. I have raised a grievance saying that the compensation is inadequate. There has been wrongful measurement. My lord, the nature of land, the nature of structures thereon have not been effectively considered. I was called for a hearing on the 6th of December 2023. There was no hearing which had taken place, and ultimately, my lord, they have now issued an order saying that, my lord, within 60 days I have to vacate. And already, my lord, after the matters were filed, got it to your lordship's notice, my lord. What they have done, I have showed your lordship, my lord, yesterday. They have started demolition the structures. My lord, I will be only, my lord, requesting your lordship that my representation be effectively considered, and if my compensation can be enhanced from whatever I have received 2 crores and odd, I am entitled to another 78 lakhs and odd in this petition.
It's under the Highways Act.
Yes, under the National Highways Act.
You have 3G file. Have you applied?
There is no arbitrator which is operating. That is my specific statement.
No, my lord,
Why not? Of course, in all the matters there
yes,
are.
my lord. And it has been appointed by the National Highways Act under the section 3G5.
That's
It is
the
not
law.
that without any arbitrator. my lord.
That's the provision.
My lord, I have specifically stated in paragraph 16 that no arbitral tribunal had been set up or constituted. No government official had been appointed as arbitrator.
Every matter arbitrators are dealing with that.
Yes, my lord. Yes, it is a process. It is a
My lord, in
process.
Howrah district. This is
Yes.
Bogasa, right?
I think it should be there in all the districts.
Yes, my lord. It has been there.
Why should your matter be?
No, I'm not saying anything. My lord, only this much. My lord, I have made a representation. I have made.
Representation.
My lord, my representation is here. Just give, yes, my lord, page 64, dated 17 November 2023, addressed to the competent authority.
Let this be treated as under 3G5. Page 74.
64, my lord.
And thereafter, my lord, they called me for a hearing. No hearing took place on that particular day.
My lord, the 3G1 amount, it has been mentioned, Lordship has received this amount of
Undoubtedly,
compensation.
I've told you.
Yes, yes.
I've told you.
And-
I shall not say something, my lord,
No,
which
no,
is not
no,
on the record.
from the record, right.
It is reflecting in my bank account. There is no dispute
Yes, my lord,
regarding.
it is mentioned, it is petition. Yes, my lord.
So your record says 3G5.
My lord, this be, my lord, disposed of. That is the only thing. If, my lord, today lock, stock and barrel they take possession, then, my lord, I will not be able to persuade the authorities.
Why not?
My lord, because, my lord, I have a dispute regarding the quantum of land. My lord, they have paid me compensation. According to me, my lord, there was a commercial structure which was standing thereon. That has not been effectively considered. Your lordship sees the.
That can be considered even after demolition, isn't it?
My lord.
Yes,
But
but,
if
my lord,
that
if the
there is no
entire
hurry-
thing goes, if the entire thing goes,
You'll still be entitled to compensation if the entire thing will in any case go because it has been acquired.
you know, there is a residential complex. I am residing there. Well, I am not going into that. I have accepted the compensation. I have today accepted the compensation. 60 days time is, you know, 60 days time is getting over on the in the 5th or 6th of January. You know, I was wrong yesterday. You know, I told your lordship 2nd or 3rd of January, but it is actually, you know, I see from the petition, you know, 1st week of January. Now, you know, only this protection to this very limited extent, if this may be disposed of and adequately
No protection is required. Let this be treated as an application under 3G5 and disposed of.
My lord.
and you know, till such time, you know,
You cannot receive compensation on one hand and then ask for stopping the demolition on the other hand. Demolition is being done on the acquired plot. They are entitled to demolition.
kindly see this big book. You know.
Yes. Apply this act.
You know, this is a manual. You know, a manual of guidelines on land acquisition for national highways under the
My lord,
National
before
Highways
that,
Act.
my lord, can I submit, my lord? Though, my lord, my senior is there, my lord. Lordship, the dispute is, Lordship, the 60 days, my lord. From what date this 60 days calculated, my lord? As per section 3E, Lordship, it has been mentioned that is not the date, 60 days not start from the date I have received the compensation. It has been mentioned when the competent authority, the National Highway Authority deposited the compensation. It has been way back. The petitioner is mentioned in that I have received the compensation on such and such date. So that's why these 60 days has not been till date complete. So I have not been entitled now to for such eviction. But section 3E, it has been very much clear from the date the competent authority, the National Highways Authority deposited the compensation from the total in terms of the total MOSA. As per section 3E, my lord.
You're on possession.
My lord, at this moment, my lord, the point is, lordship, and regarding the question of lordship, the stay does not arise, lordship, because it has been very much clear as per section 3D and this section 3E. Power to take possession.
Madam, I have already said.
My lord, I'm grateful for this, my
I
lord.
was only suggesting this if it comments to your lordship. You know, let this proceeding, whatever, you know, I have initiated, whatever your lordship seeks to convert, let it get over within the shortest span of time, and then they proceed, you know, if the determination takes place,
That has nothing to do with the 3G.
Not as your lordship pleases. But there is a dispute regarding, you know, a circulation of a notice by way of a handbill, not in terms of the provisions enumerated by law. There is a dispute regarding that. Let me be permitted to raise that dispute before the appropriate authority also.
Do you want to file a comprehensive representation?
In addition to whatever is there.
A more detailed representation?
In addition to whatever is there.
Well, before the statutory
and you know,
as per section 3G5.
File a 3G5, limitation will not be a bar.
My lord.
File a 3G5.
And my lord, I shall also be entitled to seek appropriate measurement. Kindly indicate in my lord's order.
Whatever 3G5
contemplates.
Yes, absolutely. So I'm not sending this for consideration, file a comprehensive, because this doesn't really.
Well, my lord, before the arbitrator, my lord, before the statutory arbitrator in terms of section 3G5, my lord, my lord.
Yes. The arbitrator is included.
My lord, that name, lordship, I don't even know, lordship, because as per Lordship can refer this matter in terms of the statutory arbitrator. My lord, and so they compete.
You are party to the writ petition.
My lord, at this moment, Lordship, I don't even assist your Lordship either giving your name, Lordship.
No, no, the name is not necessary. The post,
But
the
the-
designation.
Sir, that is the difficulty at this moment. Sir, জানেন আমি নামটা জানি না কি আছে যতদূর জানি ডিভিশনাল কমিশনার বাট আমি শিওর নই না না অ্যাপয়েন্টেড নেই অ্যাপয়েন্ট তো হবেই আজ নয় কাল তো হবেই রে বাবা আজ এটা তো কোনদিন এক্সট্রা হবেই আজ নয় কাল হবে হ্যাঁ
Who is the arbitrator? Can you? The National Highway
My lord, my submission subject to Lordship's correction, can the competent authority Lordship refer this matter, this application through the arbitrator, my lord, once the arbitrator has been appointed, subject to Lordship's correction?
Competent authority is
Competent authority.
Has also not been treated.
Competent authority के party करो ना?
Party करेंगे
Special land acquisition officer. The special land acquisition officer, my lord.
No, DM ADM.
ADM Why didn't you include him? Yes.
No, he is special land acquisition. My lord, please see page 66.
That has to be a এটা তো authority নয় sir.
My lord, I have made this gentleman a party. The special land acquisition collector, Howrah Improvement Trust, Howrah.
He says ADM is the authority.
Competent authority is the আপনার স্যার আপনি এটাতে যাবেন আপনি তো এটাতেই যাবেন
আরে বাবা এডিএম এ হচ্ছে ন্যাশনাল হাইওয়ে কম্পিটেন্ট অথরিটি
So let it be submitted before the ADM. Necessary steps. Heard learned counsels for the parties. Affidavit of service. The petitioner is agreed with the compensation paid to him.
My lord, just one humble indulgence. Please see page 34 once. My lord, I may be incorrect, my lord, just my lord, to assist your lordship, my lord. Competent authority, namely Special Land Acquisition Officer, Howrah Improvement Trust, Howrah. This is the competent authority, my lord, statutory.
বলা আছে
So I was correct.
Yes, my lord.
করাচ্ছি
I don't know whether any award is allotted for this. You say you are
blessings.
always
Not blessings.
Sixth respondent. The
sixth respondent
for acquisition of his land by the National Highways Authority of India. Paragraph, learned counsel for the petitioner submits that the authority is proceeding to demolish the structures standing on the said plot. Stop. Admittedly, the petitioner has received the compensation, received the award declared by the authority under section 3G1 of the Act of 1956. Stop. The petitioner seeks to file an application under section 3G5 of the Act seeking enhancement of the compensation. And prays for a direction upon the authority to consider the application at the earliest. Paragraph, learned counsel for the respondents submits. The sixth respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the sixth respondent disposed of with liberty to the petitioner to submit a comprehensive application under section 3G5 of the Act before the sixth respondent within 2 weeks.
My lord, I will submit the representation by
Within 2 weeks.
যশোর আপনাকে 2 weeks দিচ্ছে আপনি
No, I wanted, my lord, at the earliest. They have already proceeded with demolition. I had, my lord, within a week.
Within a week from date. Within a week from date, stop. The sixth respondent is directed to consider and dispose of the application Within 2 weeks?
My lord, the competent authority is the answering
Sixth
response.
Within 2 weeks from the date of receipt? Within 2 weeks from the date of receipt thereof, upon affording reason, yes?
Upon
1 week and 2 weeks.
upon hearing.
Yes, yeah, let me complete. Upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Petitioner or their authorized representative.
Upon hearing, affording a necessary opportunity of hearing to the petitioner / his authorized representative.
Same order we passed in the remaining 3 matters. Same order. Virtually same. Right? They can
Yes, why virtually?
absolutely the same. But the figures are different. The compensation figures are different.
I've stated the figure. And it's the sixth respondent?
Yes, yes. Not even the pages perhaps match.
My lord, this 60 days point is not required to mention. This 60 days calculation is not, my lord.
That's the law.
Yes, that's the law.
And he's also not on that actually. He's on enhancement.
My lord, but
He wants the construction to stop till the enhanced amount is paid.
my lord, his entire petition is
Not
lodged with the
enjoyment.
As your lordship, I'm sorry to disturb you.
As the law. Yes, next 14.
For Union of India লেখা আছে
ওই রিনি ভট্টাচার্য এসছে
এই আগের ম্যাটারটাই গেছে
আমার নামটা তো লিখে দিয়েছি
আগের ম্যাটার
এটা কি অর্ডার সার্ভার হবে না?
All by today.
All by today বলছে তো।
সার্ভার না করে বাড়ি যাবে। সার্ভার না করে বাড়ি যাবে।
অর্ডারটা কোথায় রে
15.
Your lordship will kindly come to your lordship's order in the matter. Kindly see my lord page 60.
Only the state.
Yes, no, there was no private respondent.
Yes, my lord, there is private respondent. Hubli Jinsura municipality is there, my lord.
Yes.
Sir?
My lord, Hubli Jinsura municipality is there also.
Sir?
Yes.
There is the track report.
Track report?
Where is the service?
Further mentioned there matter, that matter will be moved today or mentioning matter.
Cannot be heard without service.
My lord, we have served, my lord. But I am only on the state.
No, that cannot.
But I'll tell you, lordship, my lord.
Municipality and a private respondent.
But municipally, if your lordship sees your lordship's order,
Private respondent, please show me service first. I will not go into merits before.
well, I just before, but if your lordship feels that I will definitely come back. But kindly hear me for 1 minute. What I am seeking today only, your lordship will see. Your lordship has passed an order directing DM to take an hearing. Kindly see, my lord, page 61. I am only on that paragraph. Writ petition is accordingly disposed of, directing District Magistrate Hubli being forced to take necessary steps in terms of complaint filed by the petitioner forwarded to him by the letter dated such and such within 2 weeks. In terms of this, my lord, hearing was held. Kindly come to page.
Next 2 lines is very vital.
আরে আমি সব বলবো।
No. Date of communication of the upon hearing all concerned.
Yes.
Including the petitioner in accordance.
Yes. Now
All concerned.
Kindly come to page 62.
Yes.
This is the first date of hearing before the DM.
Yes.
Kindly note, no one else apart from my client and the BLRO was present. What I am showing your lordship, my lord, is very significant. Third paragraph. And whereas the block land and land reformed officer Chinsura, kindly read that paragraph, my lord. It is on my complaint of filling up of water body. Suddenly BLRO makes this statement. Submitted that inspection over the subject body was done twice in the month of May 23 and September 23. During inspection, no illegal filling of subject water body seen, only piling with bamboo to protect the bank of the pond is seen. During inspection, no construction material is seen over the subject body. This is BLRO's submission. Nothing on record to show that somebody else, whom we don't know,
was trying to do some construction to protect the bank of the pond. This is the statement of BLRO without any record. Next, my lord, last paragraph. This is the order of DM. Direct to cause a joint inspection in presence of BLRO, my learned friend is representing, Assistant Director of Fisheries, representative of Hooghly Executive Officer, not below rank of Junior Engineer, Inspector in Charge, Insula Police Station. Petitioner or his authorized representative must be present at the time of inspection. Inspection will be on 7th November. Co-sharers of the water body, Shoilen Dotto, Shomir Dotto must be present during joint inspection. Nothing about private respondent. During inspection, entire matter will be videographed in the presence of local witness and inquiry be done whether there is any illegal filling of subject water body or not and by whom. After completion of joint inspection, report along with videography will be submitted within 3 days before the undersigned. Well, there is no report submitted after this order. Suddenly, your lordship will kindly come to page 64. I do not know whether any report is there or not. Now kindly come to page 64. This is dated 1st December after inspection. Kindly see subject and permission. DM is writing to BLRO referring to office letter dated 21st November 2023. BLRO's letter. With reference to the above cited subject, this is to inform you that your prayer-wide office memo number as mentioned or reference accepted and permission for taking measurement of the border at Brindavan Dham, my property, within the jurisdiction of Chinchura in presence of all parties is considered and approved. So inspection was your lordship's order. DM's order was also file a report. No report filed. DM behind my back entertains a prayer of the BLRO and passes an order. Not even an order, passes a communication that your prayer is accepted. This is communicated to me. I am made a party, my lord. Then BLRO gives a notice for inspection on 11th December, page 65. Fortunately, my lord, on my prayer, my lord, that was adjourned. Now kindly come to page 70, P14. This is the notice, my lord. Again, my lord, BLRO is writing to district magistrate and collector in the team comprised of revenue inspectors for the measure in presence of the department as mentioned in reference memo. Time is fixed on such and such, 21st and 22nd today. Now kindly see, interestingly, page 71, who is marked? Serial number 9. Who is? Yes, that is my question also. He was not in the inspection. I could have understood he has made an application to BLRO for some purpose. If that was so, I should have been forwarded a copy because it is my complaint on which hearing was conducted. Inspection was held.
The pond, the water body is a government or water?
No, my pond, private pond. 3 co-sharers, your lordship has seen the name, Dottos. They are parties. We have no objection. Now, I'll tell you, lordship, what is happening. If your lordship sees a map, which I've annexed just to explain the situation, my lord. What is happening? Page 37A. Kindly see, my lord. I'll just explain the situation, nothing else, my lord.
In that case, will you delete the names of these 2 persons? Then I can hear out the matter.
Yes. Yes.
7 and 9.
Yes, your lordship will.
7, they have stated he is the interested person.
I am saying they are, BLRO is acting at the instance of this person.
No, I have not.
He is saying, he is changing the scope of the hearing.
27.
He is going beyond the DM's order, changing the scope of the hearing. Lordship, I have full instructions, your lordship can delete, but let me explain to your lordship what is the situation. Kindly see, my lord, this map once, 37A. Just to give your lordship the background, otherwise it is not necessary. Well, your lordship will see these are all private properties, which are, these lots are, which are marked here. And the pond is here, my lord. This part is mentioned as tank.
Yes.
And the top of the page is the public road and access is through this private path. Well, the car can come only to a certain point. After that, a car cannot come like any private path. Now, this person has a property here, which is also adjacent to the pond. This part, he is trying to fill it up so that the vehicle can come directly up to his property. He can do whatever he wants, my lord. I have come up to the authorities and to court saying that my pond is being filled up. That is the scope of the assessment and determination. If BLRO Suomoto says in thin air that no, it is not filling up of water body, it is trying to protect embankment. Whose embankment? Then there must be some application before BLRO. Otherwise, he cannot make this submission. So therefore, my lord, my submission is the entire hearing which your lordship directed the DM to conduct is now proceeding towards a different dimension, which is not covered by my complaint. But your lordship may kindly hear the writ petition, but kindly stay the measurement exercise which has been directed by the DM without reference to me and on my personal property. Let him furnish before your lordship first the inspection report of 7th November. And let us find out what has happened in that inspection. Why this prayer of 21st November of the BLRO will be considered Suomoto without reference to me. But I am the complainant. I am only on two documents, my lord, page 62, the first order of DM, but no follow-up of this order regarding inspection proceedings. That has to be produced before your lordship. And secondly, 64, this prayer, the BLRO, the DM could not have entertained without reference to me. He will have to satisfy your lordship that based on what happened in the inspection, taking measurement is essential and not at the instance of some other party.
So you say that this measurement is not being done in terms of this order at page 62?
No, because it is done on the basis of BLRO's prayer of 21st November, page 64. At least, my lord, the BLRO should have made that prayer before the DM in my presence when the order at page 62 was passed. He should have justified why to proceed.
But the BLRO, how will you be prejudiced if the measurement is taken?
Well, I'll tell you, lordship. Today
It may be that the measurement is part of the local joint inspection.
That, my lord, the DM should have said in my presence. Why should it be, my lord, any subsequent action being taken? First, let us come to know what happened in the inspection. Did the DM feel on the basis of an inspection report that a measurement was necessary? But I am part of the entire proceedings. Suddenly, behind my back, an order is being passed, permission is being granted.
A copy has been served upon you.
After the order. If your lordship will see page 64.
It's not an order.
It is like.
It's only a permission sought.
Yes, that is my question.
In compliance with the order passed on 1610.
No, my lord.
That is the order for joint inspection.
Yes, inspection was held on 7th November. We do not know what is the report of the inspection. Kindly see last line. After completion of joint.
You said that inspection will be held on 7th November. Was it actually held?
Yes, it was held. I have said. Not only that, the DM says report along with videography shall be submitted. I was present in the joint inspection. There was no.
It prima facie appears from page 64 that the measurement is part of the joint inspection.
Malad, with the greatest of respect, then Malad, this.
How he will prejudice if the measurement will be taken, Malad? How much quantity of the pond will be filled up?
The proceedings.
It will not be ascertained without joint measurement.
Now, therefore, it is appearing you are doing
further
this
course of
at the
action will
instance
not
of a
be
third
taken.
party.
Where do you get that?
I am getting that here only. Malad, P11, that is page 64. There is no copy marked to anyone else except the Dottos, who are the owners of the pond and the authorities. Page 70, the third party is roped in. Then there must be a particular representation by the third party.
Page 70 is pursuant to 64 and 62.
That is what I'm saying.
So the measurement is part of the joint inspection.
No, I'm not on that. Kindly see the copy has been marked on page 70.
Because copy has been marked, we cannot say that it is being done at the behest
No,
of
very
that
well. If
person.
your lordship is of that view, but let us come to page
Let the
62.
inspection be held. Let us see what happens after that.
Inspection has been held 7th November.
No, it is not correct, sir.
Inspection was due to be held.
It has been
Where
held.
is the document that it has been
It has been videographed. I will show that. I also have a videograph. Your lordship, now my learned friend is making the statement. Your lordship will call for a report from the DM personally.
Has to come. Has to
Yes, call for a report from the DM. Whether inspection was held and whether any report after joint inspection was submitted within 3 days before the undersigned. This is DM's order. I'm not saying anything else.
Yes,
I'm
Mr.
only
Bhagwan.
saying that BLRO's prayer was entertained after the inspection without reference to me, and no prayer was made in the inspection that this measurement is
See
essential.
whether the inspection was completed on that day. Maybe it was held, but I do not know whether like that a report has to come from.
Yes, that report has to come.
Yes, Mr. Bandhavadar.
Well, the petitioner's son, my lord, wrote a letter, page 45. Your lordship kindly turn to page 45. Page 45. P5. On 5th February, to the officer in charge, Chinsura Police Station, alleging some unknown persons, my lord, are trying to grab their lands and filling up the ponds. No land schedule is there. Again, my lord, your lordship, kindly turn to next page 51. 6th February 2023. Letter has been addressed to the Secretary, Department of Fisheries, Assistant Director of Fisheries, Hubli, PLLRO Chinsura Mogada Development Block, Chairman, Hubli Chinsura Municipality, Officer in charge, Chinsura Police Station.
Yes.
Alleging same, my lord, illegal filling of the ponds, no schedule of land, no plot number, nothing. Pursuant to that, the BLR has taken step. Annexure P8, page 59.
Yes.
You have an document. I am directed to, that is on 17th February. His complaint, my lord, on the 6th February. Immediately taken step. I am directed to say here is a complaint received by SUVRA Das, the resident of such and such, regarding illegal filling of water bodies situated at Bindavan Dham, and request you to take necessary action in the matter of the capacity of the competent authority under West Bengal Inland Fisheries Act by notification number such and such.
The BLRO did not take steps. Fisheries had to wake them up.
Senior officer, Assistant Secretary, Government of West Bengal, written a letter to the district magistrate. Thereafter, they moved before this honorable court. Their complaint has not been looked into. My lord, what your lordship's order was? What they have prayed before your lordship? Affidavit of service filed by the petitioner. Next page, page 6. It is submitted on behalf of the petitioner that the pond adjoining her house, in a respect of which she is undivided in their interest, is being filled up illegally. The petitioner submitted a representation before the concerned authority through her learned counsel on 6th February 2023. In this regard, pursuant to which the matter was forwarded to the district magistrate Hubli for necessary action by a letter issued by the senior law officer and ex-officio Assistant Secretary Law, Government of West Bengal on 17th February 2023. Learned counsel for the petitioner submits that no further step has been taken by the district magistrate till date. Upon consideration of the submission made on behalf of the parties, the court is inclined to hold that since the complaint made by the petitioner has been forwarded to the district magistrate Hubli for necessary action, the concerned authority by directed to take necessary steps within the stipulated time frame. The petition is accordingly disposed of, directing the district magistrate Hubli being the fourth respondent to take necessary steps in terms of the complaint filed by the petitioner, forwarded to him by the letter dated 17th February 2023, within 2 weeks from the date of communication of this order, upon hearing all concerned, including the petitioner, in accordance with law. The officer in charge in SUVRA police station during the 7th respondent hearing is directed to keep strict vigil on the water body in question and ensure that the said water body is not filled up any further. Such direction is used. Thereafter, the district magistrate has taken steps. All the parties were present, and after hearing all the parties, the district magistrate has directed a joint inspection to be held and videography be taken. Thereafter, the notice has been issued. P12, page 65.
Yes.
Fixing the date on 11th December for joint inspection and videography.
7th November inspection.
But no inspection has been held as because the petitioner made a representative P13. On their request, it is adjourned. P13, next my lord. 8th February. My client Minoti Dotto of such and sir, under instruction from such and sir, my client received a memo dated 6 December 8 December WhatsApp message such and such. Last paragraph, I on behalf of my client would like to request you to postpone the inspection fixed until 11th December. Thereafter, my lord, on the request of the petitioner, it is adjourned. And next notice issue fixing the date P14, page 70, fixing the date and joint inspection on 21st December and 22nd. Today is the date. Unless the joint inspection held, and what is the difficulty of the petitioner to take measurement? Unless it is the part of the order of the district magistrate, the order is not completed. The joint inspection is will held and it will be filed before the district magistrate and will pass the necessary order.
Let
What is
the
the harm?
report,
If
let
they
the
will
report come from the DM.
let them participate in the inspection.
What happened after this order, whether this joint inspection was held or not? My client was present, my learned junior was also
They are trying to stall the inspection.
personally present.
This is the
Paragraph 19 I have pleaded.
I am not representing the respondent number 9.
It is videographed by
9
us.
and the Hooghly Chinsura
So let it come
under
from the mouth
section
of the
17A.
DM.
Come back with a report because the petitioners say that joint inspection was already held.
This is not correct.
Para
I
19.
may come with the I may come.
Yes.
They have stated anything here. And they are-
Then councils are present.
Yes.
They have-
My learned junior was present.
over there.
So why you are not participating?
I did. If you want to
Why you are
change
not
the scope of the
participating?
hearing, we will
I
not
know it is your property.
Yes.
It is the property of your mother. I know that.
So you are entertaining a third party in my
No,
property.
no,
That
no.
is why
I am
have
not.
come to
I am not representing respondent name. Don't say so. I am not representing Hooghly Chinsura. Under the section 17A of the
Let us
United
come back
States
to
Act,
the Lordship.
Hooghly Chinsura municipality is the authority and the executive officer of the municipality will take step, my lord. But pursuant to your lordship direction, BLR will take a measurement of the inspection. Unless the BLR is help, it will not be conducted. My lord knows very well.
Do you have any document pertaining to the inspection?
হ্যাঁ সেটা বুঝতেই পারা যাবে
This
আরে
will
সাত তারিখ
not
হয়তো
be-
জানবো কি করে
This is neither here nor there, is it?
I think the Lordship will call for a report.
They have
from
not
the
annexed any documents regarding 7th, my lord. Submission be recorded.
But let my learned friend submission be recorded and your Lordship will call for a report from the
I
DM.
would like to see, a report which says that the inspection was not completed on that date.
7th.
It may be that it started on the earlier date, but
I don't know, my lord. I have no instruction. It is hurriedly moved. The leave was granted by your lordship. Because
7th
fixed
November.
today, my lord.
to stay the.
But I'll tell you,
measurement.
Lordship, for the time being, kindly,
I
kindly.
don't think it is necessary. Please participate. There is no ground for staying that.
Well,
Because
the other
prima facie, I feel it is part of the joint inspection.
But my property, now they are going to get a
Property is being inspected jointly.
no. Well, they have brought in a third party also to
Third
inspect
party
this.
has only been served. Why are you apprehensive about the third party? Third party has not
Well,
participated anywhere.
Kindly see, but because that path is a common path, he will have access. Not only that, but what is the basis also direct BLR or to
None
produce?
of the repetitions pertain to that path. It is only the water body.
Yes,
And
but
restraining filling up of the water body.
water body. Exactly.
The district magistrate has already given a direction for joint inspection. Let a report come from the state as to whether the joint inspection is complete or not.
My lord.
Well, joint inspection, well, your lordship will see they have stated here that the report with videography will be submitted. Only kindly direct whether this report was submitted before the DM or not, in terms of the order of 16th October of the DM.
It is not.
I am only on this point.
The date on next month, the 11th, thereafter it has been adjourned. Next date fixed to 25th.
I am only saying
as it appears from the record.
it was not necessary for the DM to pass this order on behind my back, because that order was passed in my presence. If this order could have been passed in
Without
my presence,
inspection and in your presence, it should not be passed.
then where
Main order, 16th October order was in your presence.
Yes. Therefore, if the DM felt
And these appear to be consequential orders.
with the greatest of
So,
respect.
wait,
But
let them come back with a report.
Well-
At the moment, I do not think
Well, your lordship will kindly in that case, well,
measurement will not be stopped because I don't think that.
well, let this measurement take place after the vacation. What is the problem?
21st and 22nd, today's 22nd already. So there's no question.
But today, my lord, is the date.
Yes, and it is already 1:15.
7th January.
Let it happen again on 7th January, my lord, we will be there.
I don't think there is any difficulty in the measurement. It has already been held today and yesterday.
Well, we are not in a position to attend the inspection. My client is an 83-year-old lady in Calcutta.
His son is representing.
His son is a practicing advocate. He is in Calcutta.
Yes.
Well, he can't go and attend the inspection right
Have
now.
you asked adjournment before the authority? 21st and 22nd were the dates fixed.
Yes, that is why, lord, what we had.
21st was yesterday. I do not know whether inspection has been held.
We are also not.
Today. So if you are not able to attend, you should have filed an application for adjournment.
But we have given them. We have filed a writ petition and we have intimated them by email that kindly do not proceed with the inspection today.
No need of stay. Or learned counsels for the parties. Learned counsel for the petitioner subjects that pursuant to an order passed by this court. On
BLRO is suo motu making statements which are not on record.
Yes.
BLRO is suo motu recording statements here which are not on record.
BLRO has only sought permission to measure.
Only to take measurement.
Before that, on 16th October, BLRO says that this is not filling up. It is
his submission.
So therefore, he is taking a
That has not
side.
been taken into consideration by the district magistrate.
He is taking a side. He is taking a side that it is filling up of it is only to protect embankment.
He is not taking the final decision. Final decision.
And therefore, my lord, DM is acting on his prayer suo motu.
No. If he would have acted on his prayer, the further joint inspection would not have been ordered.
Yes, it has been ordered on BLRO's private communication. This BLRO's communication is not given to us.
October. It was ordered in presence of all of you.
Will greatest of 16th October is upon hearing me an inspection date.
Yes.
I am not aggrieved by that.
And there is nothing to show that the inspection was held on that date.
There is one. I am making this statement on oath.
Let them come back with a report.
Yes, but kindly stay this order of the DM 1st December.
Inspection and completion of an inspection are not the same thing.
Yes, but for the purpose of inspection, DM has not directed measurement in my presence. This direction of measurement.
Inspection includes measurement.
So that
Joint inspection includes
then for that purpose, no separate prayer was necessary by the BLR.
My lord, it is also stated, my lord, during
kindly only take
inspection,
page 64.
the entire matter will
I am
be
only
videographed
concerned
in
with page
presence of the
64.
local witness.
Yes.
Is it a proper?
And inquiry will be done whether there is any legal. In presence of the local witness, it can.
It is.
I don't know who has taken, my lord. I don't know.
to show
I
that.
shall come with the report, my lord.
Yes.
Only the report of the inspection held in terms of 16th
Do you
October.
still want to expunge the names of the other on prayer of the petitioner?
On hearing prayer.
The names of
Otherwise, your lordship will be difficulty to take up the matter.
Yes, no, since you're getting some time, will you serve and come back?
Yes, I shall.
That's what I was suggesting.
In the meantime, I shall serve.
Because you're getting some time now. So let
I want them to be here.
let state come back with the report. You try and serve these people.
Yes, I shall. But kindly, my lord, say that, my lord, the inspection in terms of the further notice has not been held. Let it not be held till 7th.
No, not necessary. Not necessary. Ki bola?
But they will not suffer any
I
prejudice.
heard your submission, sir. 2023 in WPA 8068 of 2023. The district magistrate, comma, by an order passed on 16th October 2023.
And then only one submission more, my lord. If they are going to do the measurement of the pond, then his land has also to be measured. Because the state,
Whose land?
Nitai's land.
Why are you bringing
Filling
Nita
of the
into this?
pond. Allegation is
No, no,
regarding filling the pond.
then, my lord, why? I'll tell
Land
you,
is
lordship.
not matter here.
Well, they are trying to put up the case of the respondent, private respondent, that his land has been washed
That is
away.
not the case.
One line in any of the documents which shows this?
Yes,
You are only
DM's
attacking-
orders. But DM, that is what I am trying to.
I don't think further submission is necessary today. Let the report come, we'll consider.
But then, my lord, if the measurement has to be done, it has to be done of all. Why should it? How will they come to a conclusion regarding?
Water body is only the concern of the authority, not the land of the.
Then how will how will they show?
Cause of action altogether.
That is what the BLRO has pleaded. That is why he has asked for measurement.
Go ahead, it is.
Where the DLRO has pleaded.
Page 62.
Yes, what was the DLRO saying?
Page 62.
Yes.
Second last paragraph. Whereas BLRO submitted inspection, during inspection, no illegal filling was seen, only piling with bamboo.
The submission, yes, yes. But after that, a joint inspection has been. Why are you apprehensive, sir?
That is correct.
But I
Deeply
don't
obliged,
understand this.
why
If
they are
this. If
apprehending?
this order has been passed by the DM,
Yes.
then the BLRO could have made this prayer for measurement in our presence. But we do not know what is in his prayer which he has made before the DM, 1st December.
It's an interdepartmental communication. You did not know that.
No, page 60. My lord, it is like another party making an application before your lordship.
No
I will
other
not have
party.
knowledge.
I do not know why you are
About
considering
the-
private respondent at the moment, because maybe he'll.
Because
come
this
in
is
the
the
future.
entire thing is engineered at the instance of the private respondent.
That is not appearing from the record at the moment.
None of the notices are given to him. Finally, on the last day, they are giving a notice to him.
Okay, so let us wait and see what happens.
That is uphill. I am trying to show everything which is possible here.
Directed holding of a joint inspection.
But kindly record my submission only.
Allow me to complete my dictation, please. Go now. Holding, even by an order passed on. Directed a joint inspection to be held. Directed a joint inspection to be held on 7th November 2023 at 11 a.m. in presence of all the co-sharers of the subject water body or their authorized representative. Stop. The district magistrate further directed that the entire matter be videographed in presence of local witness and inquiry be done whether there has been any illegal filling up of the subject water body, and if so, comma, by whom. Stop. The district magistrate directed submission of the joint inspection report along with videography within 3 days. Within 3 days. By a letter issued on 1st December 2023, the additional district magistrate with bracket development bracket closed HON'BLE directed the block allowed the prayer of the block land and land reforms officer and permitted him to take measurement of the subject water body in presence of all concerned
This is not also issued by the district magistrate.
Yes.
Page 64 is also not issued by the district magistrate.
The district magistrate's approval is recorded there. It's issued by the additional district magistrate.
Yes, but the hearing is
approved. The first paragraph. Stop. The block land and land groups officer was directed to take necessary action.
He cannot because the
for
hearing
compliance of the order passed by the district magistrate on 16th October 2023.
Totally.
On 18th December 2023, the block land and land reforms officer informed the district magistrate that a date was fixed for the purpose of measurement of the pond in presence of the representatives of the departments and copy of the letter was served upon the co-sharers, including the petitioner herein, as well as the private respondent. Stop. Paragraph. Learned counsel for the petitioner submits that the private respondent has no nexus whatsoever with the water body in question, which belongs to the petitioner and other co-sharers jointly, and the block land and land reforms officer is acting solely at the behest of the private respondent for reasons best known to him. That is your apprehension.
Yes.
Paragraph. Learned counsel further submits that joint inspection in terms of the order dated 16th October 2023 was held on 7th November 2023 in presence of representatives of the petitioner, and the entire inspection was videographed in
Yes.
presence of local witnesses.
Yeah, local witness. Sure.
Was videographed. Stop.
Videographed.
Was videographed. Stop.
No prayer was made by the BLRO for measurement during the inspection.
No prayer was made by the Block London Land Reforms Officer for measurement of the water body during inspection. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit annexing all relevant documents, particularly as to whether inspection was held on 7th November 2023, and if so, whether the inspection was videographed in presence of local witnesses in compliance with the order passed by the district magistrate on 16th October 2023. Paragraph, let the matter appear under the same heading on 24th January.
That is long back, my lord. Kindly report, my lord, to the first week, let it appear, my lord.
First week?
Very well, 9th January.
But let them also disclose the BLRO's letter dated 21st November.
On relevant documents.
My lord, before raising, I mentioned on matter, my lord, the matter has, yes, my lord, no, my lord, kindly, my lord, the matter has already been mentioned before your lordship on Wednesday, my lord, but due to some fault in writing the item number, my lord, the matter has not been listed. Kindly list the matters immediate after the vacation, my lord. That is,
Vacation bench?
immediate after vacation, my lord.
Immediately after, you want to appear before the vacation bench?
No, my lord, this is no, there is no.
Vacation on the first day it will be listed.
Yes, my lord, because 7th, the monthly list. Because on 7th, the monthly list will be.
It's Tuesday. Why monthly list? 2nd January is a
Yes,
Tuesday.
that is why, my lord, kindly take the matter on
Monthly list should be 8th January.
8th, my lord. Immediately after vacation means.
The vacation will be included. This is not the mentioning time. I will not take the mentioning now. And upon notice also.
Yes, I have already served the notice. Actually, lordship, you are already allowed, my lord, the matter.
It was allowed, but it was wrong, isn't it? A Merry Christmas and a very Happy New Year.
Same to you, Lordship.